to writ petition relating to tender matter, Your Honor, for
For?
tomorrow. Writ petition relating to the tender matter. Letter of acceptance. should be-
Motion
Yes, Your Lordship.
tomorrow?
Tomorrow, Lordship. Much obliged.
Thank you, Your Lordship, for mentioning of a promotion matter for tomorrow, my lord.
All motions permit.
Lordship, with regards to item number 2 of the daily list, Your Lordship,
Item number?
2, Your Lordship. Lordship, we had filed an application, Your Lordship, bringing on record the reluctancy of the authorities in accepting the payment that was directed by this court. Much obliged.
For admission, item 1.
After may be taken up for some time. Advocate Ken Chaudhary, senior advocate, is coming.
Item number 1.
No.
Yes, what is it?
Led by Justice, senior advocate Ken Chaudhary, he's coming, he's in another court.
Hmm?
He's in another court.
Oh,
Ken Chaudhary.
Ah.
He's coming here. This case, let's say, reward was passed for instatement of the petitioner along with the 50% weight receipt. On last occasion, I had submitted that since the respondent is working some other association, who is not entitled to join. However, she's claiming 60% weight receipt.
okay, argue.
But he will argue. Maybe take him for some time. He's coming in.
Yes, Mr. Das, you argue. If the petitioner counsel is not arguing, you argue. What is the case about, Mr. Das?
Yes. I'm so sorry.
Yes.
This branch of law is new to me. Can I pray for little time accommodation? Actually, what would be the effect? Supposing if she is gainfully employed, as we are trying to project, what is the legal position I couldn't miss because of all these marriages in the family? I just praying for some time, my lord, so that I can assist your lordship properly. I couldn't devote time yesterday also. Now it boils down to, my lord, back wages. Now
Of 60%.
60%. And it is also a fact that she is also not gainfully employed. In
No,
such a
no, it is
situation-
gainfully employed only later on.
Yeah.
The gainfully employed happen later on.
Even then also. That is what we are trying to say.
But did you produce any evidence for that? That is the question. No, in the tribunal, the law is like this, Mr. Chaudhary. In the tribunal, if they say that they are not gainfully employed, it is the burden on you to prove that they are gainfully employed. Did you prove that aspect? If it is not there, then this court cannot touch on that.
Can we take some day after tomorrow or next week, any date convenient to lordship? To be honest, my lord, I couldn't apply my mind to the relevant subject.
Okay, Mr. Chaudhary, I am adjourning it, but the thing is, when a case is fixed out here,
I'm
the
sorry.
reason is that, you see, we have, other courts don't give dates. I
Right.
give dates. And when I give dates, the reason why I give dates is so that, no, not only that, it is easier for, means to keep a list. You may see this. It's all given here, where it is fixed. That is how I fix. No other court normally has that.
Right.
I know what are the matters are there, so this is there. Yes, but it can't go this way, means it is not in the month of December, it will go in the month of January.
Miller,
Mr. Kane Chaudhary, the learned senior counsels, appearing on behalf of the petitioner, submits that he needs an accommodation. To list this matter to address certain issues on points of law. List this matter on 6th of January 2026.
I'm deep to it. I don't write. Huh? Oh, hang on.
Leave it on 6th of January.
Item 12 and 30.
My lord, because the permission was not given, my lord, it
Mm.
could not be registered. Then, my lord, we filed, if you lord, will kindly take WPC 4548 of 25.
Yes.
Page number 47, my lord. Our application is pending since 11/2/23. Prior for issuing land lease permission NOC. In reference to the above subject, we the above applicants agreed to lease a plot of land measuring 7 bigha so and so pertaining to Piloti Potta number Iman covered by Doug number issued that Rongde Reserve Revenue map under Laluk Moza district so and so for a period of 30 years, which your permission is necessary. Therefore, we request you to issue necessary permission to lease the above mentioned land. My lord, because the permission has not been granted, we have not been able to, my lord, execute the lease deed. In the earlier round of litigation, your lordship was of the view that we should file such an application. That is how, my lord, the second writ petition was filed. On the earlier occasion, their stand was that it is a non-cadastral land, therefore permission cannot be given. Whereas, my lord, from the materials placed on record, it is evident that these are all cadastral villages.
Now, what do you say about the affidavit which has been filed by the respondent number 2 in WBC number 4548 of
Yes.
2000?
That with regard to the statement made in paragraph 12, the answering deponent begs to state Rongde Reserve is a non-cadastral village under Laluk Moza as land measuring so and so were de-reserved from so and so. Well, now they have come up with this, but we have placed materials on record to show, my lord. It is further stated that as per the report submitted by the circle officer B. Puria, a June construction is found to be situated at Rongde Reserve and in Rapsita, the.
But Mr. Chaudhary, tell me one thing.
Yes.
Means it is, although I have done a lot of revenue matters, but as well as transfer of property, can it be conceivable that the revenue does not carry out the revenue, the cadastral map,
Yes.
which they are required to
The
do,
survey.
and thereby take away the right of a particular person to sell or purchase?
They perhaps cannot.
If they cannot, then how
Perhaps
can
that
they
will be
take
the
up
man-
this plea? Because otherwise it is the mandate of law. Unless the law categorically says, yes, Mr. You are there. Yes, Mr. Borpujari. Mr. Borpujari, answer me one question. That a particular person have a right to purchase as well as sell. It can be stopped only by a procedure established. Means there has to be some law to that effect. Where is the law pertaining to that in a non-cadastral map, in non-cadastral area, there cannot be sale or purchase?
In fact, my lord.
You, just for example, I tell you, Kharguli, that Kharguli area, more particularly that particular Sunsali area,
Sorry.
as well as not only this one, this Kharguli, this particular big, what do you call that? You have a hill out there, no?
Ramsar.
Ramsar Hill.
Ramsar.
That was a NC. People purchased with permission. How did you permit those and you are not permitting here? Because unless you have a law that unless there is a cadastral map being carried out, survey being carried out, we are not going to sell. There cannot be a transfer permission. Where is that document? Where is that law?
In fact, to that extent also, my lord, we have made a query to the department. We are awaiting the instructions. Perhaps, my lord, what
No,
prima
but
facie-
therefore your ground and reasons which is given is absolutely wrong. As per what you also, that is why you are asking.
my lord,
Because there has to be some law. And that law cannot also take away the right of a particular person to purchase or sell.
Article 300A also.
Yes.
Authority of law means a statute.
In fact, that law, that judgment which was passed in the case of Ayub or something, I forgot, where the registration without the NOC by way of executive instruction you cannot,
Yeah.
which led to the incorporation of section 21A. That means you require an NOC.
Some case. Under the
Yeah,
Registration Act.
that is what. But there again, you have 300A.
A.
A person has a right. So you want to take away very well.
It's it can be only by way of law.
Law.
Law means a statute.
explanation perhaps what appears here, my lord, if lordship takes up the affidavit, my lord, filed by the district commissioner. My lord, paragraph 7 at running
read it.
page number 66.
No, your basic idea is that it is earlier it was a reserve forest.
There is another catch, my lord, why I'm saying so, my lord. My lord, at the middle of that paragraph 7, my
Presently
lord,
under-
yeah, presently survey village and mapping with improvised technology in village village. Cadastral survey of Ranga, D-Reserve, NC village could not be undertaken due to border dispute of Assam and Arunachal Pradesh as the said village shares interstate boundary with Arunachal Pradesh. As such, the village Ranga D-Reserve NC is currently a non-cadastral village. List of NC villages available in the website of Directorate of Land Records so and so. It reflects the name of Ranga Day Reserve NC. So it shares the boundary of Assam and Arunachal. That is one.
So therefore, are we to understand in the boundary areas of Assam and Arunachal, there cannot be any permission for purchase and sale?
No, my lord, there appears to be some dispute. Otherwise, my lord, lordship is well aware. The exercise that is required to be carrying out for surveying and finally bringing incorporate the same in the record of rights. The
No,
cadastration.
survey is for what? What
survey
is no?
for
What is the
cadastration.
purpose of survey?
It is for cadastration and to find out, my lord, the boundaries primarily, my lord, and then to put it up, my lord,
No, 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 no.
as well as
A person may have a right over that land. They are going to purchase from somebody.
absolutely.
So that person, you are not denying that that person doesn't have the title.
No, he is a recorded patta.
No, no. So therefore, and this patta has been issued under your aegis. So therefore, you admit that he is the owner of that land. The next conclusion is, if he wants to sell it to the petitioners, how can you stop him on the basis that you have not carried out the cadastral survey? My question is that.
That is true. That is true. That is a fundamental right, my lord. Unless and until my lord,
Constitutional.
Constitution.
constitutional right, my lord,
Earlier it was not,
and now it is 300A. But in some apex court decision, my lord, it has been touched. It has been given the color.
Human right. It's a human right.
It is almost akin to fundamental right. I must, my lord, to spell it as such, my lord.
The
It
Supreme
is
Court
almost
says
akin to
in the
fundamental.
Vidya Devi's case, it is a human right.
Human right.
It's more akin to a human right.
Now,
So
my
this
lord,
cannot be the reason. Because otherwise it will have far-reaching consequences. Everywhere. Because you have a power to regulate at best, not to appropriate, no, or to appropriate. You are trying to appropriate their right to sell and right to purchase on the basis of a thing which it was your duty to carry out.
এই কথাষাৰ আপুনি কওক। সেইটো instruction টো লৈ But if the petitioners apply in offline mode, the difficulty that has arisen, which is spelled out in our affidavit, perhaps because of the reason that they had applied online. And in the online there is less human interference. So the systems says that it is.
We have it on 6/1/2026. Okay, you given here your whatever you are saying, put it on affidavit.
This is
Let the petitioner, no, this cannot, later on it will change. Let them come up and that the petitioner is required. I am fixing 6/1/2026 is a reason. Because Mr. Chaudhary will be then prepared for this matter also. No, madam, you file an affidavit that if the petitioner files in the offline mode, you will
We
take.
already done it, page 47.
It is there, my lord.
Already there.
Then-
47.
Then, in that regard, if it is being done, then
They instruct, then I can.
what instruction? They have already filed it. Then if you are making a statement, submission that the petitioner required to file it on the offline mode,
Give the permission, through online, whether it can construct it in the, business or.
no, madam, you have to understand, you have created a system by which you have put certain things. Just for example, that day I was taking up one matter. You may be there. A person was asking for a delayed certificate, death certificate. Delayed death certificate, if you applied in the Setu portal or whatever portal it is, then you need to have a doctor's certificate. Now, this person doesn't have a doctor's certificate. So you have not conceived while making that portal these. So here you have not conceived that without the dark number properly, there is obviously a dark number, but it is in a NC area. Means non-cadastral area, there is a dark number and patta number. So therefore concern is you have to say that if it is an NC, it cannot be sold. But there are plethora of what you call the examples out here whereby you have permitted. And the most important example is right next out here where you have the Ramsar Hills. It's an NC. Then you go to places like Junarangi Road. Yes, no, that is why Ramsar Hill, Kharkuli area, these are all NC. Then you go to Junarangi Road. Go beyond that. These are also a part of those, what you call the town, what you call the tea garden, which was later on put in the name of A and it remained NC. During the last settlement operation, only the settlement was made. It was for the first time the Junarangi certain areas beyond, just in front of Gita Nagar, the Gita Mandir, from that area onwards, these were brought under the survey which was done only recently in the last settlement.
They have given patta number without survey. I can appreciate the DAG number, but the patta number you can give only following a survey. So therefore, I think their stand is something which is cannot be envisaged.
Okay, what was the first writ petition for?
The first petition was also similar prayer,
But here
Prayer
in the
because
second, there was a rejection.
That prayer was not there. That application was not brought on record. It was in that context, your lordship was pleased to observe, why not you also file a petition?
No, the first one was for some renewal permit or something. no?
Yes, yes.
Suspend the
Actually, for
include
non-registration,
of
I
operation.
was denied renewal. Stone Crusher unit. Eventual prayer is for renewal of my Stone Crusher unit, but then unless we have the lease deed, they are not in a position to do it, Forest Department. So there was an interdepartmental communication between the revenue and the Forest Department. And therefore, we have to come.
We
up with
do
the
one
sec-
thing, we keep this matter of 1634
Yes,
pending for some time.
Yes.
We dispose of 4548.
yes.
thereby directing them to do it. That this ground cannot be the ground for, and
This
they
is
are not
not
asking even for
registered.
purchase. This is the ground they are asking for lease.
Lease only.
Absolutely, it is not limited conveyance.
Huh?
It is a case of limited conveyance.
Hmm.
Limited.
But
Sometimes
unless we have the registration, we cannot.
No, you do one thing.
Yeah.
I allowed your writ petition, this one. We keep the
4.2
other one
rate.
pending because the other one has other
Complications.
various
Yes,
complications which we'll deal it later on. As to whether only on the basis of the lease deed or anything else, they may look into it. So there are other aspects which comes into as regards the permit. And stone crusher unit, one has to be again very careful.
Therefore, my lord, the conveyance is a limited conveyance. It will be leased. At the end of the day, my lord, if there is a dispute, it will revert back to the owners.
Heard Mr. Kane Chaudhary, the learned senior counsel, assisted by so-and-so appearing on behalf of the petitioner. Mr. Arbor Pujari appears on behalf of the Revenue and Disaster Management Department of the Government of Assam. Ms. Yudas, the learned additional senior government advocate, appears on behalf of the district administration. And no one from forest. None appears on behalf of the forest department when the matter is taken up. Yes, you are there, forest. Okay, Mr. KP Pathak appears on behalf of the forest department when the matter is. The present writ petition has been filed by the petitioner. Assailing the inactions on the part of the respondent authority. Not to issue the NOC oblique permission for registration of the lease deed in respect to a plot of land measuring 7 bighas, 0 katha, 0 lesser, covered by DAG number 322 and PP number 98 of Rongar D Reserve under Bipuria Revenue Circle. And further seeking a writ in the nature of mandamus, directing the District Commissioner Lakhimpur to issue the NOC oblique permission in favor of the petitioners and the landowners for registration of the lease deed. The materials on record reveals that the petitioner have installed a stone crusher unit No. The petitioners, in order to install a stone crusher unit, applied for permission by submitting required documents under the Assam Stone Crusher Establishment and Regulation Rules 2013. As it is the mandate of law or of the rules of 2013 that a stone crusher unit shall be established on a land owned by the promoter or on such land taken on lease or agreement for at least 10 years by the promoter. The petitioner entered into an agreement with whom? Have you entered into the agreement?
Yes.
With one,
Kundhan Miller.
no, Kundhan is dead.
Gopal Das.
Yes, 31.
31 Miller.
Huh?
Page 31. Gopal Das.
With one Gopal Das,
Yes. Even page 31.
who is the owner and possessor of a plot of land. at measuring 7 bighas covered by periodic patta number 98 pertaining to Dag number 322, situated at Ronga D Reserve Revenue Village under Laluk Moza on 9/10/2017. The said lease was for a period of 30 years. However, in view of section 17 and section 49 of the Registration Act, read with, what is that Transfer of Property Act? What is that provision? 105, no?
105.
105 of the Transfer of Property Act, no? Which requires more than this period to be registered.
Yes.
Madam, just
Transfer of property. How much?
Egon.
one zero seven, my lord.
107.
Leases how made? Lease of immovable property from year to year or for any term.
107 of the Transfer of Property Act 1882. The lease deed which is required to be entered into in respect to the said land has to be a registered document. Under such circumstances, the lessor of the petitioners had submitted an application on 11/2/2023 for obtaining the permission in terms with section 21A of the Registration Act 1908 insofar as the same is applicable to the state of Assam. The said permission having not been granted, in spite of various correspondences, have constrained the petitioner to approach this court by filing the present writ petition. This court issued notice by an order dated 13/8/2025. Pursuant thereto, an affidavit in opposition has been filed by the respondent number 2. In the said affidavit in opposition, the stand which has been taken that the Ronga D Reserve is a non-cadastral village under Laluk Moza. And as the land measuring 2407 bighas 0 kata 15 lecha were de-reserved from the Ronga Reserve Forest by government order dated 12/3/1972 for settlement of flood affected people, no survey of the village villages and the mapping with improvised technology in the village areas as well as cadastral survey of the Ranga D Reserve NC have been undertaken due to a border dispute of Assam and Arunachal Pradesh. As the said village shares interstate boundary with the Arunachal Pradesh. It was further mentioned that as per the report submitted by the Circle Officer Bipuria Revenue Circle, MS June construction is found to be situated at Ronga D Reserve, NC Hills, and in the draft sheet number. How is this relevant? This statement? The last statement in paragraph number 7 of the affidavit?
Or their affidavit, my lord. Actually, my lord, in the context of page 57 of the writ petition.
So you say that somebody else has been given. Okay, not necessary. This court heard the learned counsels appearing on behalf of the parties. On the question as to whether, without there being a survey carried out, cadastral survey carried out, can a person be denied the permission to purchase and sell and purchase a plot of land? More particularly, when a person, when it is a constitutional right under Article 300A of the Constitution. It is seen from the materials on record, more particularly, where is your draft chita, patta, your owners? Annexure, more particularly, the enclosures to the
21.
writ petition, more particularly Annexure A,
Predecessor in interest of my lord, this
A to
person,
C,
Gopal Das.
Gopal Das.
A to C of the writ petition. That the father of Sri Gopal Das, late Kundan Das, was the patadar of the plot of land, which is the subject matter of, which is subject to the, which is to be leased out to the petitioners. No law, nothing would be shown that if there is no cadastral survey being carried out, the district commissioner the authority in terms with Article 20, Section 21A, District Commissioner, in terms with Section 21A of the Registration Act 1908, insofar as the same is applicable to the state of Assam, can withhold the permission It is also the opinion of this court that to carry out the cadastral survey is absolutely the duty and responsibility of the revenue officials of the government of Assam. And on their failure to do so, the rights under Article 300A of the Constitution cannot be infringed. Under such circumstances, it is therefore the opinion of this court that the ground on which the application for NOC oblique permission which has been withheld by the respondent authorities, more particularly the district administration, more particularly the respondent numbers 1, 2, and 1, 2, 3, and 4. Infringes the rights of Sri Gopal Das as well as Gopal Das under Article 300A of the Constitution. First, in that view of the matter, this court therefore disposes of the instant writ petition with the following observations and directions. Number one, the respondents, more particularly the respondent number 2, 3, and 4, are directed to consider the application for grant of the NOC oblique permission in terms with Section 21A of the Registration Act 1908, so filed by Sri Gopal Das for leasing out the plot of land at measuring so and so to the petitioners. Number two, while considering the said application, the respondent authorities, more particularly the respondent number 2, 3, and 4, cannot deny the permission oblique the NOC on the ground that the village in question there has been no cadastral survey in respect to the village in question. Number 3, the said exercise be completed within the 30 days from the date of a certified copy is served upon the respondent number 2. List this matter on 6/1/2026. You have to go for a fresh agreement because otherwise your 4 months period will go. Section 26 will come in.
Obliged.
For orders item 2.
Number 2.
My lord, we sought the permission to deposit the balance amount. But my lord, deputy commissioner is adamant, he is not permitted.
Why?
No, my lord, I have received the instruction. My lord, in lordship's last order,
Objection.
My lord, I am not complaining, but my lord, the manner in which, my lord, the order of this honorable court was taken note of is something, my lord, I think time has come, something should be, some message should go. These officers at times, my lord, they exceed their brief.
So you are asking to payment of rupees 23 lakhs.
Yeah, well, some modification with regard to my lord's order dated my lord 30/10/25. If lordship may be pleased to take up that order, my lord, that is the last order.
So it was not 23.
Yes, my lordship has held, my lord, that remaining amount from 23,33,520, my lord, after deducting 2,28,000, it comes to 21. But my lord, this figure of 23 lakhs has been arrived at after deducting, my lord, 2,28,000.
Okay.
So they are required to actually pay, my lord, 23, not 21. So under that circumstances, my lord, the authorities,
Reflect letter X was mentioned as marked and in
yes,
6 pages of the letter X, madam, it is clearly stated, madam, after deduction.
You, okay, you deposit that 23.
lordship make some observation with regard to
I'll
that.
make it.
Quantum, my lord, they are
Yes,
ready.
If it is a mistake of the court for which I have fixed 21, then it will be
My
23.
lord, only to.
Failure, I take full responsibility.
Lordship may not be pleased to
Mr.
take it
Mr.
in that.
Chaudhary, take the land with 23. Don't go for all this thing. I have, you see, these are other, it is otherwise certain. I told your junior out there on the last occasion that it is otherwise very difficult. It will have a lot of other consequences, which I explained to him how.
They will.
No, they will listen. No, he has given this, na. So I'll put this again on record and now make it 23 and you deposit
Miller.
within how many days? Don't delay.
2 weeks, Miller, 15 days.
You deposit that amount. So you have deposited 21 now? Have you done? No.
No, they have refused to accept it. We've applied for it, that a permission should be given to make the balance payment. Then they say nothing, you have to pay 23 lakhs.
Okay.
Now, my lord, what we'll do, we'll make the payment. We'll not seek any permission. We'll pay
No,
the-
no, you
pay
deposit,
the
no,
amount we
you
say
you have to deposit by way of a challan.
that-
You deposit in the challan and deposit it with him, he will change it and bring it. Therefore, I want to, because I have kept the matter so that in my presence, the name also changes as the owner
Yes.
with
yes.
that.
Yes, yes, absolutely, my lord.
Heard Mr. Kane Chaudhary, the learned senior counsel, assisted by Mr. T. Kashyap, the learned counsel appearing on behalf of the petitioner. Mr. R. Borpujari, the learned standing counsel of the Revenue Department, as well as Ms. Yuda, the learned senior government advocate. Full stop. It is brought to the notice of this court that in the order dated 30/10/2025, there was an apparent mistake. There was an apparent mistake committed by this court. In as much as the amount to be paid by the petitioner for the grant of patta should have been rupees 23,33,520 and not rupees 21,05,040. Mr. Arbor Pujari submitted, the learned standing counsel for the revenue submitted that as per the zonal valuation of 1 biga 1 katha 2 lectures of land, is found to be rupees 25,62,000, and out of which rupees 2,28,480 have already been paid by the petitioner. Subtracting the said amount already paid by the petitioner was therefore required to pay an amount of rupees 23,33,520. Taking into account, in that regard, the learned counsel for the Revenue Department has placed before this court an instruction dated 24/11/2025, which is kept on record and marked with the letter. Hey, এইবোৰ মই কৰিম নেকি? মাতকচোন এই registry মাতক. এখন মই এখন ইয়াত এখন আনি পেলাই কৰিম নেকি? Isn't it the problem for them to put it out there? Huh? মই এতিয়া বিচাৰি ফুৰিম নেকি? X, Y, Z, this is a big problem which is being faced. I call that schedule from the registry.
I think now it will be Z. Earlier two letters were
Two
marked as
letters,
X and Y.
X and Y, my lord.
No, that is the problem. No, in fact, they should maintain it. They don't have the time to do it, maybe too busy. X is there.
Y was not there.
Y.
I think it will be Z.
Full stop. Taking into account the above, comma, this court grants liberty to the petitioner to submit the challan of payment of an amount of rupees 23,33,520 along with a certified copy of the present order to the
Yes.
District Commissioner Kamrup Metro. The said liberty be exercised within how much days?
My lord.
How many days?
15 days, my lord.
Within 15 days from today. है ना? Liberty be exercised. List the matter again on 15th of December 2025 for an update. And liberty be exercised to land to Nalan. The district administration, upon receipt of the challan of payment along with a certified copy of this order, the district commissioner Kamrup Metro shall, upon receipt of the challan as well as a copy of this order, shall do the needful for further processing and provide an update on the next date.
And so,
For hearing item 3.5.
What is this? Old matters?
On the 16, my lord, it has grown a little bit old, my lord. But then multiple times, actually, the counsel for the respondents have changed, and therefore, my lord, hearings got delayed. The issue otherwise involved is a very hot issue, my lord.
Where is the other side? Who appears?
As of now, honestly.
SCPF.
Recently, my lord, there was some change in,
What are you challenging?
my lord, these are assessment orders of Provident
Hmm.
Fund. These are assessment orders of Provident Fund dues. Our challenge, my lord, is only on a limited point, that the assessment has to be done by identification of the beneficiary. And that is a settled law. Now, what they have done is that they have some petty contractors who were otherwise not registered under the PF, because you need 20 members to be independently registered under the PF. So these petty contractors who had done short-term works, employing, my lord, 4 or 5 laborers, they did not have PF codes. So in respect of those contractors, what they have done is that they have taken the names of the contractor from us and say that this is the assessment due from the wages component they have calculated without identification of the beneficiary. So to whom it actually would go money, that is uncertain, my lord.
So they have directed you to pay,
Yes, my lord,
but you don't know whom to pay.
my lord. So the exercise was not done.
So why is the matter pending for last 5 years for that?
In fact, there are settled decisions of this court also, my lord, in this matter. But earlier also in.
Okay,
this
we
case,
do one
the
thing.
Same thing had happened, my lord,
No, we do one thing.
my lord,
Today we are not going to dispose it of in this manner.
my lord.
So there is a demand upon you.
Yes,
Why?
being the principal employer, saying that the contractors were under us and therefore the assessment.
Can it be so?
No, the independent contractors under the PF Act, they had to be summoned. We supplied the list. So they are not independently registered. So if you want, my lord, the names can only come up from the contractors. But instead of doing that, they have
But
done.
if you deposit, if they are asking you to pay 29,000, this is a case of 29,000, 2717.
My lord.
Now, if you deposit that amount,
My lord, PF,
the amount will go to somebody.
that identification has to be done prior to I deposit because the deposit.
But
on PF is-
how does it stop your liability? My only question is your liability.
My lord,
You have a liability.
my lord.
Is there any quarrel with that?
No. As a principal employer, if the contractor does not pay, my lord,
So it is your
it
liability.
will come upon me. It will come upon
So
me.
if it is your liability, how do they pay? Give it to the beneficiaries, their lookout.
No, my lord, their own circular says that without identification of beneficiary, there cannot be an assessment because the payment, I don't deposit it to the provident fund. PF money goes against the member's account. So firstly, there has to be a member, he has to have a PF account and I pay it in that particular account. So therefore, I.
No, let's see the demand.
Necessary.
The demand of 29,000 is to whom? Let us see the demand in the 2717.
My lord.
Where is the impugn law?
Is 147, my lord. In fact, assessment is in case annex 138 annex 32 is there.
Yeah, recovery notice.
My lord.
Dues of the undermentioned description are recoverable as per recovery notice on the so-and-so provided by so-and-so. Employee in respect of so-and-so is hereby directed to remit the area dues immediately and in any case within 7 days receipt of the recovery notice and avoid further recovery action. So this is the amount they are asking.
My lord. Here are some.
So you have to deposit to them.
No, the assessment, my lord, under.
So your liability is there. How do
Liability
they
is there.
give it? That is your lookout. Why should we go look into that?
Once a 7A proceeding, say somebody does not pay PF, then a proceeding under 7A is done. 7A is a proceeding whereby you find out what is the dues and that dues is calculated in respect of beneficiaries. Then you identify the beneficiary and open a PF account in respect of that.
No,
particular
therefore,
person.
are you,
And then only I
no,
deposit.
Mr. Pathak, are you saying that this is not the due?
This may not be also, once I identify.
So you
the-
don't know that how many beneficiaries have
My
not been intimated?
My lord.
Okay. Now, is this recovery proceedings initiated on the basis of some hearings?
My lord, they serve as a notice. They served as a notice.
No, the way that notice, there is some order passed. Prior to that, there is an order passed.
My lord.
Yes, before the Eastern Provision Commissioner Silchar. Inquiry proceedings under 7A.
7A.
So this is the order.
My lord. Daily order
After
sheet
a
was
number
filed.
of hearings, speaking order dated demand in Emmanuel being the inquiry officer conducted the inquiry assessing rupees so and so as the provident fund insurance so and so, and where is the establishment instead of remitting the dues assessed within 50 days from the remand, preferred to file an appeal against the order dated before the appellate remitting and so and so. Whereas so and so remanded the matter back, and whereas the Iman Honorable Tribunal presiding on the dispose of the case, directing the APF to examine the contractor to ascertain the number of employees engaged by them. Their establishments were also directed to appear before the EPF with 1 month failing which EPF are liberty to decide, as well none appeared for the establishment in order to place their case as per the order dated so and so. And so forth, whereas the establishment by reply dated demand pleaded to be afforded reasonable. Whereas so and so of the establishment appeared on behalf of the establishment and so that the demand was demand. And expressed the inability to furnish details of any employees due to their following reasons. The names of the workers in respect to the contractors have not been maintained by them, that due to some prefixed action on the part of the office, the information in respect to such area could not be readily provided and that some more time should be granted. And whereas thereafter one of the hearing held on demand that the authorized officers, so that they One is details of maximum number of year by the contractor without providing any details such as salary paid, and as such they were directed to provide this for asserting the table to the fund, the workers on the next date of hearing. Whereas the hearing could not be held on Zoom. That's why the venue of the hearing was shifted to where they had that fund, the table, where the hearing. But how do they arrive at 29,177? And they mention it with the balance of the assessed amount, means some payment has some amount is there.
That is
The
not reflected
thing
in
is
the
that
order,
you did not maintain records,
my lord,
as I could see. It is your failure.
my lord.
So why should we exercise 226?
Numerous such.
Your
cases have
failure.
come up.
Why are you not filing an appeal against this? Earlier you had the opportunity of filing an appeal. Why didn't you file an appeal this time?
But my lord, because at that juncture in 2016, when we came, just preceding that, my lord. this
You are
honorable court had
exactly
already
the
interpreted
same
the-
ground you are taking here.
My lord, what we have been saying,
Earlier appeal which you have filed,
my lord,
that was the same ground.
my lord,
Why should we entertain this repetition?
at that juncture, my lord, in 16, when we came, my lord, right preceding that, my lord, a similar issue had come up between BSNL and EPFO. This honorable.
Your
court
problem
interpreted-
is not 29,000.
It's not that. It's not.
What you are saying before the court that this is the 29,000 cannot, it is not the question.
My lord.
Your problem is the second direction. That thereafter the establishment shall prepare all required returns in order to credit the amount so assessed to the individual PF so and so of such individual employees after remittance of the balance of the amount as ordered.
My lord.
So,
So
this is your problem.
the current assessments, my lord, have been done.
Now you don't have
Current
that.
assessments, the
Now you
laborers
don't
got
have that.
registered with us, my lord, otherwise their PF, there is no issue.
And kindly come to this paragraph. This is what is the most relevant. Kindly come to page 140, the inspection report. The last paragraph.
140, my lord. 144.
140.
Think there's some error in my case, probably it's 144, Malak. Thereafter, the establishment shall. prepare-
And whereas an inspection squad reported that.
My lord. That the executive engineer, M. Karmakar, admitted that under acknowledgement that it's so and so, that his office failed to maintain records in respect of contractor workers as required under the Contract Labor Act. My lord.
So
Is that.
what is wrong with this order? Nothing is wrong.
That failure remains, my lord. But then the issue remains is that who is benefited by this money? We wanted, my lord, that we say that since we did not have, you under 7A have the power of inquiry of a court. I have given you the name of the contractor. Summon the contractors and get the names from them so that accounts can be opened in respect of those persons and assessment can be properly made. And in fact, previously also, my lord, precisely this is what the court had directed, my lord, in another matter between BSNL and APF, my lord. It's not that we don't want to pay. Or we are shrugging away with the responsibility, but then proper identification of the inquiry should happen, my lord. This was remanded back, my lord, saying that you identify and reassess thereafter.
Let's see the judgment of Food Corporation.
FCI matter, my lord. Food Corporation.
But this is different. Food corporation cannot have the,
My lord, food corporation.
food
has a
corporation is
PSPI, my lord,
different.
because
Food
what we had
corporation
said that
cannot be
if I don't
same.
have the record,
But the fact remains out here
yes,
that as per the Employees Provident Fund 1952, you are required to maintain the list.
the PF Act does not have any specific provision directing the principal
Or
employer.
the contract,
to do so.
the
But then
contract,
otherwise under labor laws, my lord,
now under the Contract Labor
my lord,
Act, you are to maintain the
we,
list.
we have,
So you have that list. You did not keep the list.
we did not give.
That,
2002, 3, my lord,
So-
that period. So now,
this is for which period?
2002, 3, my lord. And the assessment, my lord, they started in 2014. So what we did is, my lord, why I relied upon FCI, my lord, is that
Here,
FCI, my lord, what
in,
we
a-
did,
in the judgment passed by the learned coordinate bench,
my lord,
says that at that point of time, they did not provide. But is it your stand that they did not provide here? In this case, the court took into another aspect. That look here, there was a case challenging that you have to provide the list. Some challenged it, and as such, the BSNL authorities did not have it. Is that your case? It can't be your case taking into account that nothing is apparent in the order, past impugn order. So then on what basis this court should think that there should be an exemption? Now, what is the penalty prescribed if the contract labor organize this
that,
is
that will be a
violated?
separate proceeding, my lord. In fact, the PF Act also under section 14, my lord, has penal provisions. So what we wanted is that, my lord, we wanted a logical, of course, we did not have, my lord. We can penalize for that is a different aspect. But then the legislation is ultimately to benefit these laborers, my lord, who had worked. His money has to go in their account. So their own circular, my lord, page 47, my lord, see. This, my lord, takes up, my lord, this particular kind of situation where, my lord, the
Yes.
records are not there. Case 47, my lord, is part of a circular of 2012, which is also referred, my lord. The para A is lump sum assessment, my lord,
2717.
my lord. 2717, page 47,
What is it?
lump sum assessments, my lord. Eight, C, my
Mostly
lord.
in contractor and in establishment employ workers of migratory nature having short-term so and so. The answer is it happens because the default detection and the subsequent compliance action takes place much after the occurrence of the default. Further, the employer is either unwilling or unable to provide details of its employees when so required during the course of an, according to the following instructions they are. The establishment shall file the returns and remittance of its employees, whether regular or contractual through ECR. If the establishment has on its rolls employees who are deputed to other establishments on year, there shall be no assessment without identifying individual members in whose account the fund is to be. So you are only referring to C.
C, my lord.
But what about A and B? What about A and B? Did you
Yes.
mandate this? You cannot just pick up one. This can be followed only when you are having A and B.
My lord, if these people already had membership, there was no difficulty in remitting.
But this circular came later on.
This came in 2012, my lord.
So that is what, how will this apply? Because if I
Because the
remind,
assessment
no,
took
because
place-
Mr.
assessment took place in
No, but the
2014.
thing is, if I remand it back,
My lord,
which was done there,
my lord.
what happened to that case?
That, my lord, we summoned the contractors. Some, my lord, solutions had come up. my lord.
So
There
you have
were the
summoned the,
contractors were
no,
under
here you
70.
did not summon the contractor.
It was for them to summon. We provided them the list. Case 60, my lord, is the
So
list.
is
of
it
the
your
contractors.
case, that you will ask them to summon?
My lord, we told so, my lord. We told.
Where?
We told so, my lord. In fact, the
Where is
order-
your statement?
The order also reflects, my lord.
Huh?
In fact, otherwise in the petition, my lord, we have stated.
Where is it? What is the stand taken by them, see? Who is the other side who is appearing?
MZ Viswas, my lord, had recently, my lord, filed.
Huh?
MZ Viswas had filed Vukalarnama recently. Earlier, Mr. Day was there, but then he, my lord, withdrew.
But here in that order, at page 100, this one, where is that order? Yes.
138.
Here they say they have called these people, but they did not tender. Where is the presiding of this one? So you did not directly pay to these employees.
The contractor pays the wages.
But you didn't have also take the list.
That was a omission, my lord. Subsequently, after all these things that happened, we have started correcting. And in fact, the.
But
tender
it will be
clauses are
next
also
to impossible now.
Almost, my lord. And where does this money also go, even if we pay, my lord?
Huh?
If they don't identify the beneficiary, my lord, who benefits from this money? PF is a fund for members, my lord. PF is not a fund for.
No,
the
my
state
only
otherwise
thing is
collect,
I can very well allow it,
my lord.
your petition, but how can I remand it? Would it serve any purpose?
Maybe if some contractors.
Because
my lord, turn out,
there is
some
one,
of them, my lord,
but
probably-
Mr. Pathak, one, there is apparently there is a fault on your part
Right.
of not maintaining the list.
Right.
So that might be, if not maintaining a list, what is the penal consequences? You have to maintain the lists under the contractual year thing, no? You see here, you see,
Contract Labor Regulation and Abolition Act 1970.
where is that, they have referred to
My
somewhere.
lord, page 141.
Regulation and evolution provides for certification of the register of wages of so and so. Maintenance of so and so. The records which are required to be maintained by the establishment and also by the contract being raised. Have been the source of- Now, what is the effect of violation?
Under the PF Act, my lord,
The PF can't do anything. What can the PF do? If they don't do it, what is the effect?
section 22 onwards, my lord. Obstructions.
We direct one thing to make, for you to make the payment and further direct them to identify and pay. What do you?
Identification should come first, my lord.
The amount you are, we direct you to pay,
My lord.
but they will identify because they are to disburse. At the end of the day, they have assessed something.
They have assessed. on the
You are
basis
not,
of-
whatever may be, they have assessed. That assessment is not wrong.
Assessment is not wrong.
But whom to pay is, let them identify because the amount has to be paid by them. But you make this payment because after all, there was a mistake. The problem which I am facing is passing an order out here for remand is not the solution. It cannot be done, impossible. Food Corporation of India judgment says that there was a request made by FCI for summoning of these workers, the summoning of the contractors. The court did not do so. So what the court did is directing FCI to make the payment. The workers union who was represented out there, so there was no problem in identification there. So the workers union out there said that whether they give or not, that is not the lookout. But the court says that they have the power under 7A to call discovery and all these things. So they should have summoned him and therefore directed him to do that. So Food Corporation is on a different pedestal. The judgment by the learned coordinate bench, with due respect, remands the issue back, but does so on the ground of one thing, that at that point of time there was no requirement of having that. That some tender you have issued, so in that was the court. This court passed an order to that effect, and not to give effect to that clause. But at the end of the day, that was a tender. But at the end of the day, how do you take care of the chapter 7 of the Contract Labor Regulation and Abolition Central Rules 1971? You are bound by that. That's the law. So under such circumstances, you have to maintain it. How you maintain it, your different thing. You may have to again inquire and do whatever may be. So there I find this does not take care of these. So as you are not challenging the amount, but you are challenging on the question of identification, we direct you to make the payment and let them identify and pay. After all, the money has to go to the authority.
That is the objective, my lord.
That is the objective. At the end of the day, the thing that you are required to deposit. Now, you must have deducted it somewhere from them.
Wages component was
Why?
told to the contractor. The wages component, because they did not have membership, my lord, in PF, there was no deduction of PF. The wages component went to the contractor. Contractor disbursed it to the laborers. So therefore, the employee's contribution is also not, my lord, included here.
So normally you deduct.
If it is registered.
No, you don't
member,
deduct anything.
If anybody is registered, my lord, we did.
No. You see, whether he pays or not, that is not your lookout. So you are a principal employer. So you therefore have to pay. This amount is your contribution.
This is our.
But your contribution, I don't think you have paid to your contractor, your contribution.
No, that we have. not.
So therefore you have not paid that.
Only
So
the-
therefore there cannot be an unjust enrichment from your side also. Because if I set aside this, that would amount to unjust enrichment where they are entitled to, those people. And it shall be always presumed that they had the amount unless it is proved. So I think that is the best way. How much is the amount?
For the 2717, the amount is small. In the other case, my lord, in 1198, it is 10,46,000. And in the 2016 matter, my lord, it is 1,87,000. Amount, my lord, is not used as such. Amount is, my lord, not much, my lord, for us.
You deposit and then let them identify and pay. We issue a direction. Or we have it on Thursday. Taking into account that today nobody has appeared, and we say that as nobody has appeared, giving them another chance. And we pass that order. I think that is the best way, no?
Not on Thursday, my lord, can be on Tuesday. next.
What?
Not on Thursday, my lord.
Why?
Thursday, my lord, I am not available now.
Ask your junior to be present. This is the order which this court is going to.
My lord.
Unless the other side gives me a good, something good.
This
Oh.
issue, my lord, for smaller contractors throughout India, my lord, it is there. This labor laws are not strictly enforced. PF codes are not there for persons who are doing this temporary kind of jobs, my lord. And laborers, my lord, do suffer.
So
PF
therefore,
policy is not
are you therefore maintaining in the ECIR? You see, what is now being required, where is that page 47? Kindly come to this. It is another aspect which I wanted to inquire. But the establishment shall file returns and remittance of its employees, whether regular or contractual, through ECR. Are you doing it
Yes.
now?
ECR, my lord, is electronic credit remittance.
Are you doing it
Yes,
now?
my lord. As of now, there is no problem. This code, on all these three cases, my lord, pertains to 2004, 5, 6, my lord. And when the assessments were done in 2014, 15, 16.
But how did
10
they?
years down the line,
But
we were also.
but how did
lacking
they
funds.
assess that amount?
We gave them, my lord, the list of the contractors and also the amount that we had paid to them in respect of wages. So from-
Against the
against that particular contract. So from that
but,
wage
uh,
component, they had calculated the PF component.
so from there,
My lord.
so it may not be, it means you have given only the wages, but not how many persons were employed.
We had.
But
the
you
million
have
bills,
given
my
the
lord.
nomenclature of because you can't give below the minimum wage. So there is some wage fixed against something in the contract. So you must have given that on the basis of that. So there is no dispute as regards your payment,
My lord,
your liability.
no dispute, my lord.
There is
As
no
per
liability
SAP
dispute
contract, my
as
lord,
regards the liability. So the question is here. Chalo. Okay. Hearing remains, and this court have duly heard Mr. B. Pathak, the learned counsel, appearing on behalf of the petitioners in the batch of writ petitions. However, none has appeared on behalf of the Central Board of Trust, on behalf of the respondents. This court further have duly taken note of the affidavit in opposition filed by the respondents. For the interest of justice, this court grants an additional opportunity to the respondents to appear. Accordingly, fixed this matter on 2nd of December 2025. At 10:30 a.m. At the top of the list, showing it to be parted. Okay. So that is the order which I will pass. The identification, let them do.
my lord.
Exercise what power they do whatever may be. But the question is you pay because your responsibility is over then once you pay because you have to pay. That is your dues. You make that payment. Now,
They
what
have to-
about the interest aspect?
They have to reopen the proceeding under 7A and then.
Let them reopen, but you make that amount.
Other case, we could achieve some success.
Huh?
I know. In the other case, when we summon the contractors, we could achieve some success.
You could?
We could achieve some success, my lord. Because at that point of time, probably they were not registered. Subsequently, they have also grown.
No, you want to still,
PFPF course.
no, you want to get yourself out of this problem, or just by making the payment, or you want further to be entangled with this problem for all times to come, because this is not going to end.
We want to put it on the contractors. my lord.
Let them do it. So we therefore pass an order that taking into account they will deposit, thereupon the authorities concerned shall summon the contractor in terms of section 7A and and do the needful to identifying them. How they do it, that's the look. Because otherwise it is you have to pay, so there cannot be an unjust enrichment for your part. So on the other hand, he has to, the state can always have it. You are there.
Item six,
My lord, the respondent number two was engaged as a canteen boy of United Bank of India. And my lord, the lordship is aware, the appeals court has already held the workers of the canteen of any bank, my lord, so for the national banks are concerned. The appeals court has said that they cannot be construed to be, my lord, the employees of the bank.
Huh?
They cannot be construed to be employees of the bank, because they are the worker of the canteen. Now. You want to say? My lord, possibly my learned friend want to say something.
my lord.
Now, respondent number two, what happened, my lord, in the year 1988, the bank authority sent him to the Mizoram.
You are challenging the award.
Award, yes. Now, your lordship will see that the tribunal has weeded out a third case, which is nobody's case.
What was the reference? Whether the action of the chief
Lord,
imam
Fine.
terminating the service of imam from the imam who have rendered 17 years of service at different places is justified. If so, whether Sri Shankar is entitled to be regularized or at least be reinstated.
My lord,
My lord.
there is no finding on that issue. Now, they have gone quite contrary to this. My lord, the finding your lordship will find that there is a circular of the bank that the canteen boys, my lord, one-time circular came out way back in 2003. So that, in that particular circular, it was held that the workers who were working in the canteen boys, they will be given the job provided they found to be qualified. And they filed an application to that effect. Now, this was not in the, my lord, in the written statement. It was nobody's case, nobody canvassed to that effect. Nonetheless, my lord, the award was passed in that effect.
My lord. My
Where
lord,
did they get the circular then?
That, my lord, I have, next year lordship will find that it is 49, my lord.
My lord, may I be allowed to submit something? In this case, I was appointed as a respondent by the respondent
Huh?
number two. By the respondent number two, I am representing the respondent number two. So during proceeding, continuing of the proceeding, it has been pointed out, it has been raised that it is not appropriate on my part to take part in this case. Since I took part in the reference case against which the petition has been
He
filed.
was the presiding officer in some point of time.
No, I was
So
presiding
when
officer.
it is called, Justice Hete, said that whether it is proper on your part to be the counsel.
He was a presiding officer.
Well,
Yes, my lord.
You are the presiding officer of this award.
Yes, not award, my lord, just for a short time, I took part in the proceeding. Thereafter, my term of appointment expired there and I order dated 4/9/2025 may kindly be seen, my lord.
Okay. So you have tendered your
Withdrawal,
disengagement.
yes.
Your
Order
name is Mr. L.C. Day.
LCD, my lord. Order dated 4/9/2025. It has been clearly mentioned by this honorable court that it will not be appropriate on my part to represent the respondent number 2. And accordingly, I issued this notice.
Okay,
Yeah.
we'll take care of it. Don't worry. Yes,
No, your lordship may see at page 49,
Obliged, my
the
lord.
circular.
Obliged.
now I see there are 2 awards or 1 award.
Yes. The file, there is earlier one award is there, that is way back in 2004. And the award was passed way back in 2010. Now, my lord,
So you are challenging the 2010.
no, I'm challenging the latter one, my lord, which was passed in 2018.
Okay. So this is again against whom?
Against this particular respond number 2.
Now earlier award is what?
Earlier, there were, my lord, 97 workers. They were said to be canteen boy.
Hmm.
And there was, your lordship may see their affidavit, which your lordship will find it is. Wait. My lord, the affidavit filed by them at page 38, your lordship will find the 97 workers. And then the award your lordship will find at page 40, the award dated 25/10/2010.
So how does this award have any relevance to this one?
Relevance in the sense your lordship may see the present award. I'll take your lordships to the relevant part. At page, lordship may see the penultimate, at page 46. Last para, page, para 21. On consideration of the materials on record, as well as the submission made by both the sides, it appeared to me that claimant Shankar Nath, the present respondent, my lord, was a canteen boy of United Bank of India, Dulabchara branch, and sometime he was also engaged by the bank, though without any written order, to work as casual worker in the bank. Certain exhibits, and more particularly exhibit so and so, would show that at some point of time, claimant Shankar Nath was worked as casual peon in UBI Dulabchara branch. But there is no material to indicate the exact period of his engagement in the bank as casual worker. His service was discontinued in the year 2008. It is also absolutely clear from the award of reference case 20 of 2004, that is the earlier reference case, 2024, that the direction was given by this tribunal to the management of the bank to consider regularization of 97 workmen in subordinate cadre of the bank as per the eligibility criteria mentioned in the circular of the bank dated so and so. That is the, my lord, I have shown to your lordship at page.
Now, Sankarnath was one of the persons, one of the 197 persons?
Yes, yes,
Okay. So there was a direction at that point of time for implementing,
exactly.
implementing and considering.
Yes, yes,
Now, how did you consider it? Those persons?
yes. Now, what happened, my lord? In 2008, he was sent to Mizoram with some materials. Now, he went there. Now, after that, my lord, even in his evidence, he has stated, since I fell ill, I came back. And he never communicated to the bank in the local office or in the regional office. After this, he abandoned in the year 2008. Award passed in reference case number 2004 was in 2010. Now, it was his bounden duty, although he has abandoned, he was required to file an application, and he will file that application, and if he is eligible, then his candidature could have been considered, but he did not do all that. Even it has been admitted in the, the cross-examination of the, Shankar Nath. So that is the position, my lord, and your lordship will find, it is not automatic, the reference was made, but then he is required to file an application in terms of the, appointment of subordinate employees. I have shown to your lordship page 49 regarding
Page?
canteen boys,
Page?
page 49. Is the circular dated 29/10/2003. This your lordship will see the appointment of subordinate employees from the eligible canteen boys, casual apparatus of the bank as one-time measure. Bank is pleased to announce that a scheme for appointment of subordinate employees from the eligible canteen boys and casual laborers of the bank has been adopted as one-time measure. Canteen boys working for canteen run by the canteen committees of the employees of the bank and also casual laborers enlisted in Badli panels of various stations who satisfy minimum eligibility requirements will have to undergo a process.
No,
of-
only thing, Mr. Doctor, I find a bit problem with this award is the direction in respect to absorption. There should have been direction for consideration.
It should have been.
It should have been, like in the earlier case, they say that you implement those guidelines and consider these persons concerned.
Yes, exactly.
Yes. But what was done out here is the management of the year shall take appropriate step to implement in respect of absorption of so and so in the so and so subject to his eligibility in terms with the provisions of the aforesaid circular.
Yes.
Now, whether he fulfills as per the aforesaid circular or not.
That's the question, my lord.
So if that is a question, that is another aspect.
Yes.
You are therefore to consider as to whether he fulfills as per the conditions. If he does not, you reject, otherwise you give.
Exactly. And therefore, my lord, it was on his part, it was his duty to go there, file an application. My lord, your lordship will find.
No. But the question is, if he has not filed an application, you can reject subject to eligibility in terms with the provisions of the year.
Yes, exactly that.
So what is there to challenge this award then?
Now, the order is like this, my lord. Your lordship will find the para 22. The management of the United Bank of India shall take appropriate steps to implement the circular dated so and so. In respect of absorption of, say, Shankar Nath in the subordinate.
Subject to his eligibility
eligibility.
in terms and provisions of the aforesaid circular.
Yes,
So as per his circular, he is required to submit an application.
yes.
He has not submitted the
Yes.
application. So you take a call on that.
That is the only, my lord, our grievance, my lord, because,
So we
And-
clarify that aspect.
yes,
Nothing you mean?
this is very short point involved in this case.
No, because 1 lakh we have paid.
1 lakh, because the proceedings are pending.
No, 1 lakh you have to
No,
pay.
that of course, my lord, the lordship.
You
may-
pay him that 1 lakh.
Yes,
And this, we just said it that it will be dependent upon whether he qualifies. So it will be at liberty for you to take into consideration.
That is.
It cannot be, because there cannot be a direction by the court.
Fair.
That is not what it is required. You are appearing for?
Respondent number 2.
Okay. Now, you see, Mr. Counsel, if you see paragraph 22, paragraph 22 seems to be worded in terms with the 2010 award in respect to the reference case of 2004. If you see that award, it says, as to whether the persons concerned, the canteen boys would be entitled as per that circular or not, it is subject to the decision of the authorities. One. But however, if this is if these persons concerned duly submitted those applications and it is pending, so therefore there was a direction to consider their case. So this is the basis. Here also in this case, the court followed that award and said that the petitioner herein is one of the 97 persons who were their canteen boys, whose case was covered by that award. So under such circumstances, kindly consider his case if he meets the criteria as set out in the. So there is the word consider is not there, but it appears from the reading between the lines that it is a direction to consider. They have to consider it. How they consider, they don't consider, that is their lookout. I'm not on that. That is not the subject matter. But this has to be mentioned as it is on the direction to consider. Because they use the word subject to. Subject to eligibility in terms and provisions of the aforesaid circular issued by the bank. So means there is no direction to appoint him. His appointment is subject to fulfilling this area. And this subject to is a consideration to be made by the authorities concerned. So that's it. 1 lakh you are going to get it, nothing more than.
No, sir. Actually, before my oral submission, please allow me to submit one written submission.
What?
Before my oral submission, please allow me to submit one written submission.
What is your written submission?
The award in response to reference case number 20/2004 is in
No,
force
no, no,
till
no.
today.
What is the
lord.
direction passed by the court? Let us hear. The council, you should not have made that submission. Moment you made the submission, it led me to look into paragraph 20. And 20 is very disastrous for you. Why did the learned tribunal direct payment of rupees 1 lakh?
Actually, there is two reference cases. One is 20/2004 and another is 15/2013. 2020/2004 is between management and association. And
But that is not the question out here, because you see the reference, the labor code can't go beyond the reference.
Both the award
Whether the action of the so-and-so in terminating the service of so-and-so from here, where's the termination letter? Let us see. Where's the termination?
No, there is no termination at all.
So there's no termination letter.
they terminated me verbally, sir. But it was confirmed by the letter 7 of our affidavit in opposition.
Nothing, but in fact, the finding is also there that you were working, you were employed by the canteen people. Some committee,
Initially,
and
I-
thereupon intermittently you have been working. Now, the fact that whether you come as a workman within the ambit of the section
Yes,
2S
sir.
is another question. The court did not give that finding. This is a very, very important
Their
aspect.
employability relation exists. Employability relation exists.
Where?
My lord.
It cannot be.
I was,
Mr. Counsel, where can there, how can there be a employer-employee relationship when the court has directed you to be employed? To be considered for appointment?
appointment in case of 97.
There is no question of reinstatement here. Mr. Counsel, you have to understand there is no question of reinstatement. What is being directed? The direction is that you see, he was asked not to continue. Thereupon, after 5 years, you
After
raised
se-
an industrial dispute, and as such, you should be paid 1 lakh. What is the basis? I was giving you 1 lakh, that also now I can't give you.
I worked in different capacities, my lord, not as canteen boy, as sweeper, as night watchman, as peon, as casual laborer.
Mr.
Several duties
Mr.
several
Counsel,
years of time.
Mr. Counsel, you see, if you see, to become a workman, you have to have a continuous period of
You-
240 days, isn't it? In 12 months period, you have to have 240 days.
Yes,
Where is it? Where have you proved? Where have you proved?
from 1991 to 2008, I worked during 17 years. And there was issue, I was issued.
No,
one
you were
identity card.
working as a canteen. Where is the finding, Mr. Counsel?
I was issued one identity card where they mentioned me as a peon. I have submitted it. They were issued one letter to liaison officer Mizoram to issue one inner line permit. So employer can request, outsider cannot request.
Oh, if the bank manager tomorrow
That
asks
has
somebody
not-
to somebody that this person is going for some work of mine and intermittent works out there and says that to kindly provide an intermittent permit,
They-
the inner line permit that makes that he becomes an employee.
Why they will request? They requested on the
Very
basis
bad
of
case.
transfer me.
I
from
think
the
we should
employer
interfere.
to Mizoram.
No,
One
no.
employer can transfer.
This 1 lakh is also bad.
Shankarnath himself, he stated in his evidence that I was appointed as a canteen boy.
Huh?
He himself admitted that I was appointed as a canteen boy.
And other capacity also. Started as a canteen boy, then afterwards, please go through the annexure 2 to 7 of writ petition. You will find that we have worked in several capacities.
Annexure?
2 to 7 of writ petition.
What annexure 2? Appointment as canteen boy. Temporary night watchman. Located in a remote control environment, so and so is located in man. Moreover, student in India garden-based in respect to the above, it forward herewith the application of a man who offers his candidature as so and so. This is
Annexure-
written by somebody. Somebody says
Pra-
that thereby forwarding his candidature. Annexure 3. In a branch is temporary engaged for night guard with effect from 3/7/2002. United Bank. There. Canteen cook. Again, you come to canteen cook. Regularization, so and so. Regularization, issuance of inner line. We would like to inform you that Sinhala, a casual employee of her friends, is transferred to our new Mizoram University.
My lord, please look into Annexure 7.
Seat. We are sending insurance. Mr. Dotto, what do you say about Annexure 7?
Yes. That-
Page 22?
That I have seen, my lord.
Hmm?
Now, this is by the senior manager. My lord, he is not the authority to say all that. My lord, your lordship has find that there are some certificate issuing by the branch manager. that-
No, I'm not on that.
My lord,
This document says that you have transferred him.
I would like to inform you, Shankarnath, a casual employee of our Durlachara branch is transferred to our new Mizoram.
How do you have the power to transfer somebody unless he is being appointed?
The terms used by the certain managers without knowing what they were doing. My lord, in fact, if he was really appointed as a casual worker of the bank, that ought to have been proved by them also, because they also will find under section 25B, they are required to say that they have continuously worked for 240 days. In order to say that this is an illegal retrenchment and all that. That submission is also not there nowhere. So because they can't do that, because they could not prove that, even the finding of the learned judge is very clear that how long he worked as the casual employee, there is no any proof that your lordship will find in very candidly it was said, my lord,
Paragraph 21.
paragraph 21. On consideration of the materials on report as well as the submission made by both the sides, it appeared to me that claimant Shankarnath was a canteen boy of United Bank of India, and sometime he was also engaged by the bank, though without any written order, to work as casual worker in the bank. Certain exhibits, more particularly 7 and 9, would show that at some point of time, claimant Shankarnath also worked as casual peon in UVI Durlachara branch. But there is no material to indicate the exact period of his engagement. And it is their burden to prove that he worked for 240 days.
Kindly come to page 101. Admittedly, the present canteen boys, workmen, have you got it? That is of the earlier award, page 12 of 2010 award. Page 12, internal page 12.
Your lordship is saying page.
Internal page 12 of the earlier award of 2010.
Right.
Admittedly, the present canteen boys, workmen have not complied with the requirement as prescribed in the established principles law. So their services cannot be regularized. But the real issue as it appears involved in this dispute is whether the canteen boys have complied with the requirement of the circular dated so and so, and whether they can be appointed as subordinate bank employees. It is evident that the canteen boys were applied for appointment as subordinate employees of the bank as per the circular dated so and so in the prescribed form, issued by the bank, duly countersigned by the respective branch managers. Thereafter, nothing has happened. They are still hopeful of getting appointment in the bank. However, it is not known to this court as to whether recruitment process has started or not. Having heard both the sides and so, the management is hereby directed to take appropriate steps, if not already taken, for proper implementation in the spirit letter, and if the canteen are found suitable for RIA in view of the Iman, they may be considered. Now, taking this paragraph 15 and 16 and reading the same with paragraph number 21, let us see how it works of the present award. His service was discontinued in the year 2008. It is also absolutely clear from the award dated so and so that the direction was given by the tribunal to the management of the bank to reconsider regularization of 97 workmen in the subordinate staff as per the eligibility criteria said. Admittedly, present claimant so and so is one of those 97 workmen, but there is nothing on record to show whether his case was considered by the management or not. It therefore appears to me that the present reference can be disposed of with the following direction. The management of the union bench shall take appropriate. So this is to relook. This is a direction to comply with the earlier direction. And apart from that, pay the rupees 1 lakh.
Yes.
This is the two. So why you are not considering? Have you considered or not?
He has to file an application. He did not come after 1988, he abandoned. Then he did not come to the bank because he has to come and file an application. And if we find he's qualified, he could have been, my lord. But then he never came.
But that is why I'm saying paragraph 21 says that he is one of the 97.
That's correct.
And paragraph 16, 15 also of the earlier judgment says that they have applied. How do you take care of these? That is why I'm saying, why I asked you to read paragraph 15 and 16 of the earlier judgment is that the court has come to a finding
Yes,
that he had applied. And this, if you read these, they applied for appointment. And then in paragraph 21 says that he is one of the 97.
right. My lord, the question is,
How do you take care of that?
there are 97 workers. Now, the court possibly found that many persons have applied for that and really applied for that, and some of them got also. They have been regularized also in the meantime. Now, this person, he never came. And this was not taken care of in the earlier occasion, whether all these 97 persons applied for the application. That remark was in the context that some of the persons applied for and they have got it. And so far he is concerned, it is our, my lord, genuine case that this person, after abandoning the bank, he did not come forward either in the regional office or in the branch office. That we have stated in our pleading as well as in the evidence also.
Have you stated he did not apply?
Yes, he did not come means, my lord, since he did not come, and that will also be there, my lord, I'll look at the evidence also.
My lord, Annexer K of our additional affidavit, page number 6. This is the application where I applied.
Which one?
Where?
Annexer K of our additional affidavit,
Page?
page number 6 is my identity card, which was issued by the bank.
Annexer K is different. That
And
is not.
7
Is
is my application.
Annexer L.
Annexer JKL. Annexer J is my identity card, K and L my application. I submitted.
So this application was filed in the year 2003.
In response to this circular, my lord. But I was not informed.
So this application is there. There's a seal.
That is, my lord, 12/11/2003.
Yes, no, therefore, Mr. Dutta, therefore I am saying paragraph 15 and 16 of the earlier one has to be read with this paragraph 21.
The award was passed on 2010.
Yes.
Then, my lord.
No, Mr. That is why I'm saying, if you see paragraph 16, 15 of the earlier award, they say that they have applied.
Again, my lord, Annexure E of our affidavit in opposition, page 72. This is the letter, they have dismissed me. They agreed. Annexure E of our affidavit in opposition, page number 72. Branch manager admitted to his regional manager, chief regional manager. In this letter, they admitted. And Annexure J is my identity card.
There's a stay operating, Mr. Datta.
There is, yes.
Hello.
There they
I think we should
mention
dismiss your
me
petition.
as peon.
We'll dismiss your petition.
My lord, no such, my lord.
With
Now-
cost.
Now, one thing your lordship kindly see. Now, he has applied and he is qualified, where is that? So he will has to be qualified. Because your lordship can,
No, that is a document
no, your lordship kindly see. the
where
qual-
there is a certification to the effect that he has worked for 17 years. How do you
17
take
years
care of that?
He will have to
After-
satisfy section
After
25.
dismissal, I was
He
residing
has worked for
in a remote village.
25B is okay, but that I will take care of it in my order. Don't worry.
Your lordship
With
kindly
this
see.
means it with cost of 50,000
At page 50, your lordship kindly. see.
and interest
So
back
that's
wages.
That's a different issue. But your lordship kindly see at page 50.
After dismissal from service, I
What
was
is that, page 50?
living in a
Page
remote
50,
village
lordship
of
kindly
Assam.
see.
How can
Yeah.
I know this development without any information from management?
Process of selection and then page 49 eligibility. The casual laborers who have completed 240 days in 12 consecutive calendar months in any of the years in the past. To be eligible, casual laborers should have registered their names in the employment exchange, and the requisite certificate to this effect is to be produced with the application. Now, admittedly, my lord, there is no finding of that he worked for 240 days. And if he hasn't worked for 240 days in a given year, now in that case, my lord, he is not eligible because the eligibility criteria is that.
What is that judgment you have referred to? State Bank of India versus State
Yes,
Bank
That
Company.
is, my lord,
Annexure J of my additional affidavit also, there is
2005
identity card.
SCC,
So employment relation exists, my lord.
2005
These
SCC
two
531,
document is
paragraph 39. We therefore hold that the employees of the canteens which are run at various branches by the local implementation committee, as per the welfare scheme framed by the SBI, would not become employees of the bank, as the bank is not having any statutory or contractual obligation or obligation arising under the award to run such canteens. Hence, it is not necessary to decide the second question that these are the things.
No, there is no quarrel that he is not an employee of your bank.
My lord, now another aspect, your lordship.
In a substantive position, no, but you have a circular.
Yes,
Now you have not acted as per the circular.
now he has to be qualified. The first
He is qualified. As on 2003, was he qualified or not? This is the certificate which has been given. This was
certificate-
duly accepted.
Now your lordship will have to see whether he worked for 240 days in a given year.
Now, why should this is already given out here in the certificate? It has been said that from so and so to so and so 240 days. If the casual laborer stayed the period of year 1/1/2003 to 28/10/2003. And
Yes.
this is further been here by that letter issued by them. You are not denying this document not to be genuine. Where is the document of termination, reconsideration?
I have
Date?
mentioned it in my application.
Your affidavit, you have filed one document, na? Where is that? Where is that document?
Annexure J of my additional affidavit, page number 6.
J no, J is no. There's another one by which you have been given that he worked for 17 years. Where is that?
Annexure K, page number 7. In
Page
this
number 7.
application, I have mentioned, I have a
No,
word.
you showed me one document now. Where is that? Why judgments are enclosed with the pleadings? The council, you showed me one document. Where is that? First of all, you don't have the page number, which is regular with us. Ah, got it. Page 122. This document is an exhibited document.
Which one, my lord?
This is issued on behalf by the manager.
No, these are all annexures, my lord. These are not executed.
Huh? Have you looked into the records whether this document is there or not? Let us see.
These documents are there. It's in in petition. No, my lord, my learned friend has shown that they have applied. Now, I have an argument on that, my lord.
Now kindly see your exhibit 4. Exhibit 4. Have a look at exhibit 4.
More of which one?
Exhibit 4, you're arguing a labor court matter, Mr. Sir. Exhibit 4 cannot be a part of the writ petition. It is an exhibited document. Yes, you must be having an exhibit 4.
No, before that, my learned.
No, before that, no, kindly come to exhibit 4. This answers your question.
uh, Can I see that?
No, you have it, you are not prepared with it. It's very sorry. See this document? I think the labor court actually did not give him what he was actually entitled.
No, my lord, before that.
No, not
Just-
before that. This exhibit 4 is your answer.
Oh, my lord, does it spell that he worked for 240 days in a given year?
Huh?
Does it spell that whether he worked for 240 days in a given year?
This is clear. Your person did not deny it, na?
And furthermore, my learned friend had stated that after the reference case order date, I mean 2010, the reference court's order, he filed an application. Well, it's not true at all. This application is filed in 2003 for applying. before
No,
the
no, in 2018, he filed an application that the order passed by has not been complied with. Because he's not required to file another application. No, but Mr. Doctor, where is it mentioned that you have to file another application as per the award?
That-
No. No.
Application in response to circular, my lord.
No.
That in the reference court, he did not file. What happened, my lord, is an application of 2003. He applied for an appointment of casual worker. That is the letters. And in terms of the order which I refer to your lordship at page 49, he is required to file an application before the bank. He never filed that application.
Award 2004 still is in existence till today.
Nobody.
It was not challenged in any forum of court by the management. It is still in force, my lord.
The MW2 says, I have no comment in respect to Exhibit 9 because at that relevant point, I was not posted at Dulebchera. Tongkornath was sent to Mizoram in connection with loading and unloading some bank properties at Mizoram University branch. And since entry into Mizoram needed inner line permit, the bank might issue the same because I was not the bank manager at that point of time. What is UBIR SETI? What is that? Achar. Capacity of director UBIR SCTI. What is that?
From where your lordship is reading that?
He's the management witness number 1. I'm the director so and so.
I'm the director UBI. I'll have to ask them that.
But he was specifically put the question of that document, which says 240 days.
But then he has said again, if your lordship. is
And he says he does not deny it. He, on the other hand, says, I have seen, not this. Yes. From here, I worked as the head cashier and then a manager of so and so, so and so. Exhibit 2 appears to be a document issued by the branch manager. Exhibit 2 to 7 appears to have been issued by the bank.
But then, my lord, if your
And
lordship-
these are documents. How did these documents come into being is the another best part. You may not have looked into the record. This was done from the bank.
Now. the
There was a notice to produce, and in pursuance to that, these documents were produced by the bank.
The main question would be whether, my lord, in terms of section 25B of the Industrial Dispute Act, my lord, if I read it, my lord, a workman shall be said to be in continuous service for a period if he is for that period in uninterrupted service, including service which may be interrupted on account of sickness or authorized leave, or an accident or strike which is not illegal, or a lockout or a cessation of work which is not due to any fault on the part of the workman. And number 2, where a workman is not in a continuous service within the meaning of clause 1 for a period of 1 year or 6 months, shall not be deemed to be in the continuous service under an employer. We come to A clause.
Well, clause A is for mine.
We are in Roman 240 days in any other case.
Yes. Now here, if you see Exhibit 3, that is why very important. Exhibit 3. It categorically, this is dated. Exhibit 2, Exhibit 3.
That I've seen, but then
Yes.
in view of that also.
Yeah, this is to certify that so and so has been working as a casual layer on daily basis since the last 10 years he has been working regularly with effect from 1/1/2003 to till date, and date is 15/11, meaning thereby he has 240 days.
Nonetheless, my lord, it will have to be proved by them that they have worked in a given year 240 days.
Don't worry, I will do it. I will take care of that. So therefore, it is a case of reentrenchment. We will remand it back to the trial court. That it is a case of retrenchment, wrongful
I'll-
retrenchment has been
I'll
done.
take-
And therefore you are entitled to all these benefits.
Now,
No, Gammon India takes care of that, my lord. That is
the
the,
judgment of this court dated 19/1/2023. It was mentioned the learned senior counsel, however, fairly submits that in an earlier reference case number 20/2004, the said circular was directed to be implemented as it was still in existence. He submits that if the earlier award has not been challenged by the management, there may be possibility of the workman in the case to get the same benefit as per award passed in earlier case. This order of this court dated 19/1/2023.
and furthermore, my lord, lastly, your lordship will find there has to be an application by them after the award passed in 2010.
No, no, not necessary.
Where is that application?
Not necessary. Because of the reading of paragraph 15 and 16 read with paragraph 21. It is not necessary.
That means, my lord, the award was passed in 2010
Uh.
and he filed an application in 2003 knowing that
That
award-
is why. No, no, you see, all these 97 people, whoever it is, filed application in 2003. Then came the reference in 2004. During the pendency, the reference, and therefore the judgment came, wherein it says that all these people have applied. So now, therefore, there was a direction to consider. Now, this is further being exemplified in paragraph number 21, wherein the Supreme Court, another award says that he was a part of the 97. This is paragraph 21 is relevant for that portion, that he's a part of the 97.
Earlier.
And as such, why he has not been considered? And therefore, to consider if you have not considered.
The question your lordship will require to deal. Now, they were the casual worker. If they were the casual worker, how they can be regularized? Now,
Why?
the constitutional mandate is there.
No, no,
will
they
have
are
to
not
have-
regularized. They are to be considered because they are considered in terms with that circular.
Lord, the
Uma
circular-
Devi is different. Uma Devi or all the other constitutional mandate judgments which you are referring to are on a different ways, like, where there is no post. Nothing is there. And the government does not have a scheme. Then in that regard, the High Court under 226 cannot direct. There is no quarrel with that. Understood, it cannot. So they can, however, when you have a scheme for bringing them or absorbing these people, and if you don't exercise that power, that is subject to judicial review. That is subject to the powers to be exercised by the court on the ground that it is a constitutional mandate also. The court is not asking you to frame a scheme, which obviously, in view of the Bandipora judgment, the court cannot direct. But you have a scheme. Why you are not taking them when they have already filed an application? That is the
One very interesting question, my lord, is required.
Yes.
there. Because, my lord, if he's a casual worker, in that case, the question of law would be now whether he can be regularized by passing an order. Because the Supreme Court in a case say merely because it is before the industrial adjudicator, the law should not be different. So the law will be in the same.
Mr. Doctor, kindly show me one judgment of the Supreme Court that where there is a scheme for absorption, which you have as per that circular. The Supreme Court says that then also the court cannot direct them to consider in terms with that scheme. Show me one judgment by at 2 o'clock. Industrial Disputes Act. one, no?
Sorry, my lord, I'm a bit late.
Yes.
My lord, so far the question of 240 days is concerned, is the burden lies on the workmen, my lord. They are to prove that. The 240 days, whether they have worked 240 days or not, the burden lies on the workmen.
Where is that Supreme Court? In which case it
Yes,
is?
there are 2, 3 decision, my lord. I will take your lordship to that. One is. My lord, I'll give it to your lordship right now, when my junior has gone to bring it. And that is reported in. Krishna Bhagyalal versus Muhammad Rafi. That is. Nana is like. This is reported in 2009-11 SCC. Page 522. 522. Paragraph would be paragraph 8. Hello.
Internet to ভাল পাব। What do you say about 2010 3 SCC 192?
Which one, my lord?
Paragraph 16.
Yes, paragraph 16. That is the rule of last come first look, without any tangible reason.
But anyways, he has proved that 240 days. That is not the issue.
My lord, so far, the finding given by both the tribunal, it is given that, my lord, we should consider his case. Now,
Hmm?
for that purpose, my lord, his presence is required. He did not go after he abandoned his job in 1988. He did not go to the bank,
19?
1988.
But it is not that he was working out there. That is the evidence which is given that 2003. He was working in 2013. 3. That particular thing is being categorically mentioned. That is Annex 3.
No, that's true. my lord.
Exhibit 3.
After that, my lord, when he was, my lord, sent back to Mizoram, so admittedly, he said he fell ill. He came back from there. Now, after that, he did not report to the bank. Now, that is the position.
Then what are these Exhibit 2 to 7? These are evidence which has not been denied by you.
No, no, that is, my lord, your lordship will find.
Annexure E of my affidavit in opposition. letter written by branch manager of Dulachara branch to his chief regional manager. A request for reconsideration of the dismissal of the casual boy, Sri Shankarnath. This is to inform you that as per instruction, we have dismissed the casual boy, Sri Shankarnath, from the branch for 17 years continuous service. And he had come with tears to request you, good office, to consider his case to re-employ him as the canteen boy of the branch and generator operator. We find him as a since and good character.
He's saying,
This
my
is
lord,
the
I
admission.
was discharged
Yeah, I
in
was dismissed.
2008. He said himself, I was discharged from 2008. Now, our case is, he is abandoned on that date. After that, he did not come forward.
Why I shall come?
How is it then? If that be so, then what is about this document which I've said, Exhibit A?
This is earlier.
2008, I'm not concerned. We are more concerned about, no, the
This
thing
earlier
is,
period.
no, the thing is like this, 2008.
I worked continuously from 1991 to 2008. There is no break.
And thereafter you have discharged him.
No, no,
So
he
the
has
question
abandoned.
of
He said-
240 days in a year does not arise in this case.
That is okay, but Mr. Doctor, he had work from so and then you were discharged.
he did not come. He abandoned.
No, then why is that the letter, which is the, you have not denied that letter? That is also an exhibited document.
You can see on his own, he is saying, he has discharged, then the MW1 has said,
Where?
he has abandoned at page 95, you can see.
No, let us see, exhibited document, exhibit 1, certificate, exhibit 1 is this certificate. Exhibit 2, to whom it may concern, this is of 2001, 2002, 2003. Okay, to whom it may concern, this is the of 2008, date of issue is of 2008, issued by the senior manager, identity card, designation, UBI peon.
If your lordship look
Then-
at the evidence of MW1 at page 95, my lord, he very.
Then these are the
categorically stated,
documents which are there. Now this document is there, 2017, 11, 2008.
Yes.
Request for reconsideration written by the senior bench manager to the chief regional manager.
Yes.
This is to inform you, as per your instructions, we have dismissed the casual boy so-and-so from the bench for 17 years, and he has come with tears to request your good self to reconsider his case for re-employment as so-and-so, so-and-so. Thereafter, you don't take him, you don't reconsider him. This has led to the next industrial dispute.
Your lordship, can you see what is the evidence? Shankarnath, what he has stated. My lord, I'll just, for your lordships, my lord, your lordship, can you see that?
No, it is a different thing, Mr. You have not challenged the notification
Just.
for making the reference.
Your lordship, can you see at page 73 what he has said? I became ill, came to Silchar only. I have not submitted any copy of intimation letter in the court. Now, if he has intimated us that he has joined to either regional office or the branch office, in the court he has said.
Mr.
I did not
Mr.
intimate-
Dutta, I don't think I have been able to convey it to you properly. 2008, you dismiss him. Thereafter, on, the branch manager writes to the regional manager, kindly consider him. You don't consider him. Then he does not do anything. Then after 5 years, he makes an industrial dispute.
Exactly.
And thereupon, a reference is being made in 2014. This reference says whether he was terminated illegally after working for 17 years and as to whether he should be regularized or whatever may be, that is the consideration. Now, the fact that after 2008, where can he join you? If you have not reconsidered his case, have you reconsidered after 2008? Tell me, after Exhibit 9, that communication which was written by the branch manager, manager to the chief regional manager, you have reconsidered your stand that you are going to keep him? Why is he going to join you?
What they have come for it.
Where? He came. See the letter, Exhibit 9, which is Exhibit Annexure E.
E.
Show him that letter. Let him read it.
That, my lord.
So there he goes there. You don't reconsider, and now you are making that submission. But it is a very sad thing that the Learned Labour Court went into on a different tangent. The Learned Labour Court should have looked into it that it was an absolutely an illegal retrenchment and thereby or termination, and thereby should have directed him his employment and give him whatever may be the back wages.
For that purpose, my lord, is it not the duty of the workman to establish that in a given year, preceding the termination that he completed 240 days? There's the law, my lord, on the field.
If there is continuous service,
Let me finish. You do not know the procedure of the court. So that was the incumbent upon them.
What was incumbent?
My lord, 40 days in a preceding the termination period, if we understand in the 2008 he was terminated. Now preceding that year, my lord, he has completed 240 days of work.
Where is your plea in your where is your plea in your written statement?
Nonetheless.
No, Mr. No, Mr. No, I won't allow you to raise that unless you have taken the plea.
Section 25B is.
No, absolutely no. Unless you raise that plea, that cannot happen.
Pardon, so far my knowledge goes, it is up to them.
No, it is not. Let the Supreme Court look into it. There's no worry with that. But this is what is.
Our case is that he did.
No, where have you raised that plea? That prior to his termination in 2008, he did not have 240 days.
We have said that he is not a workman under section 2S.
No, that is a different thing.
Then he was.
That has no.
employed,
That is another aspect to the matter. We are not on there.
And there is no relation between the workman and.
That won't help you. Where is it you have taken? Because the other exhibit 9 categorically shows that. Now determination 25B. For the purpose of this chapter, a workman shall be deemed to be in continuous service for a period if he is for that period in uninterrupted service, including service which may have been interrupted on account of sickness or authorized leave or an accident or a strike which may be illegal or not a lockout of air which is not due to any fault of him. Where the workman is not in continuous service within the meaning of clause 1 or for a period of 1 year or 6 months, he shall be deemed to be in continuous service for a period of 1 year if the workman during the period of 12 months preceding the date with reference to the calculation to be made had actually worked under the employer for not less than 100 years if it is ground and 240 days in any other case. For a period of 6 months if the workman during the period of 6 months calendar preceding the date with reference to which the calculation is to be made has actually worked under the employer.
We are under remand too.
Now, let us read 2A and 2A properly.
2A.
Yes, 25B 2A. Where the workman is not in continuous service within the meaning of clause 1. What is clause 1? A workman shall be said to be in continuous service for a period if he is for that period in uninterrupted service, including service which may be interrupted on account of so and so, so and so and so and so, or cessation of work which is not due to any fault on the part of the workman.
Yes.
Where a workman is not in continuous service within the meaning of clause 1 for a period of period of 1 year or 6 months, he shall be deemed to be in continuous service under an employer for a period of 1 year if the workman during the period of 12 months preceding the date with reference to which the calculation is to be made has actually worked under the employer for not less than 200 in any case. Now, what is the date? Where have you taken that plea? Let us see your written statement.
Written statement, of course, it was not in.
No, then nothing.
It was.
You
in
can't
case
read
where
those
Lord,
details.
that we have said that he is a multi-
Whether the action of the chief general manager in terminating the service of EA from the EA who has rendered continuous 17 years of service at different places is justified. If so, he is regular to regularize or at least to be reinstated. Now, claimant of the workman, so and so, work boy, he initially engaged in vacancy of so and so. And so, nevertheless, in Iman, according to the poor chairman, claimant has been working so and so. The claimant submitted thereafter he supplied with the format of filling up the submission motion of the claimant to the post of Iman. The said format was filled by the claimant dated Iman and submitted the authority. Claimant in EI equivalent register in Iman number Iman became a member by submitting his membership. Issued a certificate for the claimants that they could be capable labor. After the which Mr. Counsel, tell me one thing. The reference which was made was whether the termination was bad, and if so, whether he is entitled to reinstatement, whether he is entitled to regularization or reinstate. That was the reference. Regularization presupposes that the person is in service. If a person is not in service, there has to be a termination, there has to be something there. One has to hold the termination to be bad, isn't it? Now, the learned labor court did not come to a finding that there was a termination which is bad, or there was a termination. Labor court gave you 1 lakh on the ground of non-consideration. If you are not in service, how can there be a direction for you to be considered for the purpose of being regularized or brought into service by way of that particular circular? First, the termination has to be held to be bad. Because the reference is there, because the labor code can't go beyond the reference. Whether he can be regularized? Yes, he can be regularized provided he is in service. But he admittedly was not in service for the last 5 years. That's an admitted fact. So the question of regularization does not come unless the termination is held to be bad. Now, you have given me judgments that this court should not interfere under 226 with the appreciation of facts. How do I interfere with that?
Actually, I was terminated in the year 2000, November 2008.
No,
You-
you were terminated in the month of March 2008. That is your evidence. In November 2008, the letter was written when you again went back
First
to
week-
that
first week of
person
November.
concerned and say that kindly request him to so and so.
I went to the Mizoram in the month of, last part of July, 2008. I came back from Mizoram in the month of August 2008. I was terminated in the
So
month
you were
of,
discharged from in the month of,
in the month of November 2008.
but your person, the person who is there, on November 2008, okay. November 2008.
During the proceeding of a case that is 2004, without taking permission from the court and without intimating the court, they have dismissed me.
Very well.
So dismissal, in one sense, dismissal is illegal. Another,
No, that is wrong.
in the meantime,
No, that is wrong. But how can this court go into that aspect?
in the meantime, the judgment of 2020, 2004 came into effect. So
2010.
Accordingly, I should get the my regularization as per circular number. That is,
No, but isn't it the regularization presupposes that you are in service? How do you take care of that situation?
I
I
was
have, Mr. Counsel, I have all sympathies for you. You have worked out there for 17 years. But the fact remains one thing, that there cannot be a regularization unless you are in service. But you were rightly or wrongly or illegally terminated. This termination was a question of reference before the tribunal. The
Right.
tribunal did not decide that. Problem arises with, if you had filed the petition before this court, it would have been different. But the tribunal did not decide that aspect. Rather, went into another thing and said that these should also be considered. How do you take care of that situation?
After termination, the reference case number 2004 came into effect. As per this, 97 workers were ordered to absorb. I am also one of the worker of this.
Because you see, you have not even raised that aspect in your written statement that during the pendency of those proceedings, you have been discharged.
Yes, I raised it.
You have not taken black plea also. What you are saying. That could not have been done. Because if there is a dispute going on, then you have to maintain status quo as regards the status. That is there. That is also not your plea to that effect. What is your plea out here is that you have been working out there, you have been written letters, everything. But the problem arises with this court is how the directions passed by the tribunal. 1 lakh is okay. We may additionally make it 5 lakhs. But the question remains, how do you take care of that situation? That is a very difficult thing.
Because the previous award, this is 2004.
We are
One-
not
one-
concerned, but
one-
we are not concerned with the enforcement of that award.
No.
We are not concerned with the enforcement, and even if that enforcement of that award is also concerned, it is a case of consideration. If it is a case of consideration, whether you fall in or not. Now, the fact that you cannot be considered, taking into account that you have not been regularized, you are not in service. Whom do you regularize? A person who is already there in service.
Sir, the 1 lakh was given in the award passed in reference case number 59/2013. And the regularization order was in continuation of 2004.
Understood. So that is another subject matter, which has nothing to do with this case. What the court did, the labor court, means sadly so, instead of going into the reference, deciding the reference on the basis of all these facts, came up at paragraph number 21 that all these things, it is not so clear and all. And also came to an opinion that you are one of the 97 employees who have submitted application. And as such, your question also should be considered. But forgetting that you cannot be regularized if you are in service, if you are not in service. Because isn't that one of the preconditions? You see, it says subject to be eligibility. Now, eligibility is that you have to be in service on that date. Isn't this, Mr. Doctor? Problem arises there. It is not what Mr. Doctor says that you has to file an application. No. But the question is, how do you get it? You cannot be regularized unless you are in service.
I was in service during the proceeding of the 2000.
Understood. But you see, therefore, the court should have held that the termination was bad. Then only you can be construed to be in service. Where is that finding? If the termination was held to be bad, it could have been. But if I was the labor court judge, I would have passed that order. But can I pass that order in 226 when it is not your petition, his petition? That's the problem. We increase the compensation. 3 lakhs.
Live up to your Akshay's best judgment.
3 lakhs. No more. 3 lakhs you pay him enough. It's a sad thing he did not file a writ petition. But can't help it. Compensation was less. And I tell you why they have terminated you. As I could bear the entire file now. Because you told the dacoits Look here where the key is. When the dacoits were beating you up. That's the reason. And the dacoits looted 10 lakhs. Otherwise, they would not have put that question to you during cross. They didn't want to show, put it out there in the objection, they did not say anything. The fact that you were there inside the bank when the dacoity happened, meaning you were employed there. Otherwise, you would not have come for a cup of tea or given a cup of tea, the dacoit should not have come. And if you were just a canteen boy, you would not have known where in which drawer the manager kept the keys. These were pinpointed questions which have been put to you in the cross-examination. That is the reason why you have been terminated. Later on, something happened, the regional manager came over one day, the senior manager said that, chuck him out. Whereas your good friend, who was the WW1, he was not thrown out. But he was thrown out in the year 2010. So I increased the compensation to another 2 lakhs. Let them go wherever.
Another prayer, can I request your lordships to get the court master to switch off the
Huh?
AC for some time?
What?
AC is troubling me a little bit. You are having cough and cold.
AC. Okay. That AC is off. My AC won't be there. I put it at 25. Okay, AC.
There is no regulator, there's the problem.
There's no regulator. Other people will suffer. Anyways, it's a bit cold. But without the AC, you can't work here, nah? You have to open the door.
Yes, sometimes you'll have to put off, then again switched on. That way, not other courts functioning there. No, my lord, I'm traveling a lot. It's-
So that is the only way out. Give him additional 2 lakhs more. There's no way out. That is a sad thing, but you can't help it. And you see, by the time a lot of time has gone, 2008 we are concerned, we are in 2017, years have gone by. What do you say, Mr. Rudd?
It's the only possible way, what I feel. It's the best way to.
We
solve
may
the
increase the
situation.
compensation by 2 lakhs more. That's the only way. This court feels sad taking into account because the point of reference was not decided.
Not at all. He did not go to that. He rather.
He should have
become-
decided that point of reference. But if I remand it back, it makes no sense of a dispute of 2008 coming up in 2025 again remanding it back. The dispute arose in 2008. You raised in 2013. We are in 2025. The mandate of the statutory mandate of the industrial.
In the year 2011.
Huh?
Employment started in the year 2011.
Employment.
This as per circular.
What?
We want to
Circular-
say circular was issued in the year 2011.
Engagement of canteen boy and casual worker.
No, that is okay. Circular started in 2011, but the court could not have passed that direction. You were not in service. The basic mandate of that circular, which was given in 2011, means that you were in service. Isn't it the mandate? Where's the circular?
Page,
How were these people get
49.
wage?
49. It was issued on 29/10/2003.
Ah, it came into effect in 11.
No,
No, no,
2003 itself.
employment started.
And it was later on withdrawn on 2011.
after passing of award in the year 2010.
So this was withdrawn.
Yes.
That is another aspect we are
No,
not
no,
concerned.
not would.
But how can if it was withdrawn, then how can the court direct?
Withdrawn in the year 2000 afterwards. And this is this is also a fresh document in this court only. The management suppressed this circular in the,
Say unnecessarily suppress. What suppression? We have annexed it and you are saying suppression.
it is
Don't
a
tell
fresh
us, Lord.
document, my lord. They did not present in the tribunal.
My lord, it is
To
not the
develop
case, it
circular.
is nobody's case and. he's
Okay,
saying-
tell me, Mr. Counsel, when the circular was issued, you applied in the year 2003. At that time, your age was 23. Did you have 8 years? Did you have 8 years at that point of time? You couldn't have, because your date of birth is in the year 1980. So 8 years back, we say, did you work out there in the canteen from 15? That can't be possible. So your application of 2003 did not satisfy the eligibility. See your identity card. What is the date of your birth?
3/10/1980.
So the day when you applied, you did not have the eligibility. Because the mandate is the canteen boys who have worked for not less than 8 years uninterrupted as on the date of issuance of the circular. So as on the date of the issuance is 2003. Uninterrupted for 8 years means you have to work from 2015, 1995. 1995, you were just 15 years. How can you work? Chalo, I think I tried my best to find out something, but otherwise I read the entire records somehow. But
Yeah,
the
Lord,
sad
because-
part is the basic fundamental, not the judgment what he has said. In fact, their witnesses knew more law than the facts. They were witnesses referring to Uma Devi, State Bank. But the sad part is there was no lawyer who could have cross-examined them on that. Then it could have tested their veracity. Chala, let me come back and allow his petition reluctantly.
Lordships peruse the file more than us.
Huh?
The Lordship peruse the entire file more than us.
Yes. No, I've looked into it. It's very sad. The sad thing, but in fact, the mistake was committed by the labor court, and you should have filed a writ petition. And it is too late in the day to permit you to file. In fact, the labor court, this is a case I can't determine now. The labor court, in view of the various judgments of the Supreme Court, I could, forget about Supreme Court other judgment, the judgment which you have placed it before me also. I can set aside that award in his favor. But in your favor, how can I set aside? But otherwise, I would have to hold something else, a determination I have to go. The determination was bad. In fact, his case, your case should have been centric to that. And in fact, that was your case. If you see your the written statement file, that was your specific case, that you worked for all these years. Till 2008, you were working. You did everything. And there were good commending letters which were given to you. But one fine day, the senior manager comes and throws you out. And they also then don't say the reason why. The reason can be seen from the cross-examination. Because when the dacoits beat you up, you said that manager kept the key there in the drawer. Let me come back. Heard Mr. S. Dutta, the learned senior counsel, assisted by so-and-so, appearing on behalf of the petitioner. And Mr. So-and-so, who appears on behalf of the respondent number 2. Full stop. The petitioner herein have assailed the award dated 22/2018 passed by the learned presiding officer CGIT cum Labor Code Guwahati in reference case number 59/2013. Full stop. For deciding the legality and validity of the award, dated 22/2018, hereinafter referred to as the impugned award, it is relevant to take note of some of the brief facts which led to the filing of the present writ petition. A circular bearing number PD/DIR/31 OM-370/2003 dated 29/10/2003 was issued by the United Bank of India for appointment of subordinate employees from the eligible canteen boys/casual laborers of the bank as a one-time measure. The eligibility conditions were provided in clause 2 in respect to canteen boys and clause 3 in respect to casual employees, laborers. The eligibility condition, insofar as canteen boys were concerned, were number 1, that a canteen boy who have worked for not less than 8 years uninterrupted, as on the date of the circular, in any canteen run by canteen committee of the employees of the branch/office of the bank, where at least 25 numbers of employees are posted, would be eligible to apply for the post of sub-staff. In that regard, a certificate from the canteen committee duly authenticated by the head of the concerned branch oblique office of the bank for the period of the work in the canteen is to be produced along with the application. The second eligibility, number 2, the canteen boys should have registered their names in the employment exchanges, and the requisite certificate to that effect is to be produced before the bank management with the application. Subclauses B and subclauses C relate to age and educational qualification. In respect to casual employees, which is in clause number 3, the casual laborers who have completed 240 days in 12 consecutive calendar months in any of the years in the past. Secondly, the casual laborer should have registered their names in the employment exchange, and the requisite certificate to that effect is to be produced with the application. Clause 5 of the said circular stipulated that the said circular, that the said scheme was a one-time measure and would cease automatically within the completion of the said process. Full stop. In the backdrop of the said circular, it is very pertinent to take note of that a reference proceeding as an industrial dispute arose between the management of the United Bank of India Zonal Office, Ulubari, and the workmen represented by the President, United Bank of India Employees Association. Which was referred to as, which was and a notification under section 10,
Yes.
10, was made by the appropriate government referring the following, making the following reference to the Central Government Industrial Tribunal, there's come Labour Court, Guwahati, hereinafter referred to as the Learned Tribunal. The reference which was made reads as under page 90, whether any employee-employee relationship between so and so, so and so, so and so. The said proceedings, which were registered as reference case number 20/2004, were disposed of by an award dated 25/10/2010. paragraph 16 and 15 and 16 of the said award being relevant is reproduced herein under page 100 and 101. From a perusal of the said award, above quoted paragraphs, it would be seen that the learned tribunal directed the petitioner to take appropriate steps, if not taken already, for proper implementation of the circular dated 29/10/2003. And if the canteen boys / workmen were found suitable for appointment in view of the above circular, their case may be considered by the management bank. It is relevant to take note of that the said award had attained finality upon being notified. Next. While the said proceedings were, while the said in the backdrop of the above, it is further pertinent to take note of the case of the respondent number 2. The respondent number 2 claimed that he was initially engaged as a canteen boy as well as a casual laborer at the UBI Dulav Chera branch, Karimganj, with effect from 20/2/1991. It is the further case of the respondent number 2 that the branch manager of the UBI Dulabchara branch had intermittently issued various directions since the year 2001, thereby directing the petitioner, respondent number 2, to carry out various forms of work like night guard on casual basis, broom and wash the bank premises on casual basis, and even certifying in the year 2000 on 15/11/2003 that the respondent number 2 have been working have been rendering service with effect from 1/1/2003 till 15/11/2003 as a casual laborer on daily basis. The petitioner, the respondent number 2, had also submitted an application on 12/11/2003 in terms with the circular dated 29/10/2003. For being absorbed as a subordinate employee this certification, which have been issued by the branch manager of the UBI Dulabchera branch, have been issued from time to time in favor of the respondent number 2. It is a further case of the respondent number 2 that he was transferred from the Dulabchera UBI branch, Karimganj, to Mizoram in the new Mizoram University branch of the UBI. And this aspect would be clear from the letter dated 28/7/2008 issued by the senior manager of the UBI of the petitioner bank. Justo. Thereupon, the petitioner on account, the respondent number 2, on account of his ill health, came back to Karimganj and again joined the UBI Dulabchera branch. The respondent number 2 thereupon, while rendering service in the month of August 2008, were verbally terminated
Terminated
verbally
November.
on November. In the month of August, November 2008 was verbally terminated. And this fact that the respondent number 2, was terminated is evident from the letter dated 17/11/2008 issued by the branch manager to the chief regional manager to reconsider the termination of the petitioner of the respondent number 2. The respondent number 2 thereupon submitted various representations to no avail. And therefore, full stop. And And as the dispute continued, comma, a notification was issued by the appropriate government thereby referring the dispute to the learned tribunal. The question which was referred reads as under page 106. Upon the said reference being sent to the learned tribunal, a reference case being reference case number 59/2013 was registered. The record further reveals that both parties exchanged pleadings and adduced evidence. The learned tribunal by the award dated 22/2018 held that the petition respondent number 2 was entitled to a compensation of rupees 1 lakh. And further, consideration the petitioner bank, management of the petitioner bank were directed to take appropriate steps to implement the circular dated 29/10/2003 in respect to the absorption of the respondent number 2 in the subordinate cadre of the bank, subject to his eligibility in terms and provisions of the aforesaid of the said circular dated 29/10/2003 issued by the bank. The said direction were to be complied within a period of 3 months from the date of receipt of the award. The respondent of the petitioner bank being aggrieved has approached this court by filing the present writ petition. This court, by an order dated 6/9/2018, issued rule and further stayed the impugned award dated 22/2018 passed by the learned tribunal in reference case number 59/2013. It is seen that pursuant to the notice being issued, the respondent number 2 had filed an affidavit in opposition, as well as also an additional affidavit. Contesting the claim of the respondents of the petitioner. At this stage, it is of vital importance to take note of. That prior to the award being passed, impugn award being passed on 2018, the circular dated 29/10/2003 was withdrawn by the United Bank of India on 26/2/2011. In the backdrop of the above, this court have heard the learned counsels appearing on behalf of the parties. And have also perused the materials on record. The issue involved herein is as regards the legality and validity of the impugn award, and more particularly, the directions passed by the learned tribunal directing the petitioner management to consider the case of the petitioner in terms with the circular dated 29/10/2003. That too when the said circular was not in existence when the dispute was referred to the learned tribunal and the reference proceedings were initiated in the year 2013. Mr. Datta, are you contesting this rupees 1 lakh?
In fact, I did not make a prayer to that effect.
This court further finds it relevant to observe the submission of Mr. S. Datta, the learned senior counsel appearing on behalf of the petitioner, that the directions that without prejudice to the rights of the petitioners in respect to the other directions in the impugned award, the petitioner is not contesting the directions to make payment of the compensation of rupees 1 lakh. Under such circumstances, the question, therefore, of going into the legality or validity of the directions in respect to the payment for payment of an amount of rupees 1 lakh is not gone into. The question, however, arises. The contest in the instant proceeding is as to whether this court can permit the directions so passed by the learned tribunal insofar as consideration of the case of the petitioner in terms with the circular dated 29/10/2003 to subsist taking into account that the said circular is no longer in operation, even prior to the dispute having been referred and registered before the learned tribunal. The law is well settled. That the court as well as the tribunal cannot direct absorption unless and until the state or the employer has a scheme for absorption. It is also no longer res intriga that the court cannot also direct formulation of a scheme by by the employer. In the instant case, the learned tribunal, instead of deciding on the question as to whether there was a valid termination, deciding the issue as to whether there was a termination, whether the termination of the services of the petition, respondent number 2, was justified or not. Directed the respondent authorities, the petitioner herein, to consider the case of the petitioner, respondent number 2, in terms with a circular which was not in existence. That too also without taking into account that that circular was not a part of the records. Not an issue involved in the said proceedings. It is the opinion of this court that the learned tribunal was therefore not justified in passing the directions upon the respondent, upon the petitioner bank to implement a circular dated 29/10/2003, which was no longer in existence, and to consider the case of the respondent number 2 in terms with the said circular. Next. This court also cannot be unmindful of the fact that the learned tribunal, on the basis of the materials on record, ought to have considered as to whether the petitioner, the respondent number 2, whether the termination of the respondent number 2 was valid or not, was justified or not. As noted above, the termination of the respondent number 2 happened in the year 2008 as alleged. And as on the date on which the present petition is being taken up, 17 years have passed by. Remanding the said dispute again to the learned tribunal for decision would only and would only lead to further agony of the respondent number 2. It is the opinion of this court that the dispute between the petitioner and the respondent number 2 requires to be brought to a close. The materials on record show that the respondent number 2 had rendered substantial years of service, as would be apparent from the very communication dated 17/11/2008, issued by the chief branch manager to the chief manager of the petitioner bank. Under such circumstances, it is the opinion of this court that the compensation which was awarded to the respondent number 2 is less, is meager. And as such, this court enhances the said compensation from rupees 1 lakh to 3 lakhs. Next. Accordingly, the instant writ petition stands disposed of with the following observations and directions. This court interferes with the impugn award dated 20/2/2018 passed in reference case number 59/2013 to the extent of the directions issued upon the petitioner bank to implement the circular dated 29/10/2003 and to absorb in respect to absorption of the respondent number 2 in the subordinate cadre of the bank number 2. This court enhances the compensation to be paid to the petitioner, to the respondent number 2 by the petitioner from rupees 1 lakh to rupees 3 lakhs. The same be paid within a period of 30 days from the date of the present judgment.
Item 1011 fixed at
The records be returned. Yes, what is this?
Herein, your lordship, the matter pertains to settlement of market.
Huh?
Settlement of market, your lordship.
Settlement of market.
Yes. 156/2025, an NIT was issued. An NIT was issued, your lordship, for settlement of various market under the jurisdiction of Walpura Zilla Parishad. And the present petitioner, he had submitted his application in respect of Bhuvneshwar daily market. your lordship.
What is the stay?
Stay is there, your lordship, not to finalize the
Finalized.
Yes.
Stay is continuing.
stay is continuing.
Now what has happened? It has been given to somebody else.
No. Presently, my instruction is that the market is running by the department.
You quoted the highest amount.
In respect of the past NIT, your lordship, the petitioner, the financial bit, it has not been upheld, your lordship.
Which one?
The financial bit was not upheld in respect of the past NIT. And the petitioner,
Why there are two writ petitions?
to market, your lordship.
Two market by two different petitioners.
Why both are taken together?
The NIT is the same NIT, your lordship, perhaps this is.
Okay, who you want Mr. Khan's your matter, na?
Yes. The
Your
first
Khan's
one,
matter is some Buduchor daily
daily
market.
market.
Now the NIT was cancelled.
NIT was cancelled and thereafter the second NIT was issued.
Retender. was-
Retender was issued. And the initial instance, your lordship was given liberty to the petitioner to submit his tender in respect of the second NIT. But due to shortage of time, he failed to.
Okay, now let us see what is that.
Your lordship, kindly see the affidavit filed by the respondent number 4, your lordship. It's just
Filed by respondent number
4.
2.
4.
Who is he?
Starts from page 48, madam.
Affidavit in opposition filed by respondent number 2. I am the chief executive officer, so and so. 2 bids were received in respect to the settlement of when the petitioner was one of the 2 bidders. However, both the bidders were found technically not responsible.
Basically, the contention of the respondent number 4 is that for better participation and for earning huge dividend.
What?
The retender was issued, your lordship, for better participation.
Why is it not responsive? What is your name?
Responsive, your
Mahmood Dars.
Yes.
Why is it not responsive? You did not give the Bakizai certificate
Visa certificate
and PAN card.
PAN card.
Then
But in fact, your lordship, these two documents,
PAN card is required. Bakizai may not, but PAN card is required.
but as per the terms and condition of the NIT, I think these two documents are not at all.
As per
required.
tender, my lord, Bakizai also required, my lord.
So somebody said to me, Bakizai not required.
No, my lord.
There was some
Clearance is
judgment.
required, my lord.
Huh?
In the condition itself is there.
Where? Condition stipulates the matter over. So what is wrong? Where is the condition?
My lord,
There is 31 your lordship kindly see, only given.
Where is
31
it
of my
required?
Petition your lord,
Huh?
a repetition.
Pradip
NIP.
Namudas.
Yeah,
Where, which term? PAN card?
PAN card is not. PAN card is not there, your lordship.
Oh, there must be some form somewhere.
I have also not found anywhere, your lordship, regarding Pakistan.
Why are you going to this PAN card business? Where is the PAN card? What are the certificates which are to be given? Nowadays you have made your
PAN
bid.
card, your lordship, that is not.
The tender shall register and
that-
submit agreement so as mandatory to follow the rules. Every tender shall pledge to the Gwalpaya fixed deposit of so and so shall attach. The attached passport size photo, tender shall guarantee shall verify a certificate of no defaulter from the Gwalpara Iman. Every tender shall incident for the police involved in any violent expression. The ESL itself certified authentication of the document. The tender funds. So where is the PAN card required? Where is the Bakiza certificate required?
PAN card is.
Both of you have not read it?
My lord, 17, clause 17. In SME's version, I am reading, my lord.
How can a no defaulter from Gwalpara Jilla
Kormuk-
Parishad can be said to be a
Kormukta, my
Bakizai?
lord. Kormukta is clear. Maybe it's
From
written as
whom?
Pakizai.
From whom?
From the this is Zilla Parishad, my lord.
So can there be a Kormukta from Jilla Parishad, a Bakizai certificate? Can it be termed to
This
be a
is not a
Bakizai
Pakizai
certificate?
actually, my lord.
Huh?
It's not a Pakizai.
Then what is that? Nobody gave PAN card.
Not, yes. In fact, my lord, he participated in the retender, my lord. Yes, my categorical submission is there. In the other case, my lord, the Mukut Medhi.
No, not here.
Hmm.
But herein, your lordship, for non-submission of these two documents, my tender.
Wait. Let us not go to Mukut Methi. Let us first go to this. What is your Buduchur? What is this? Comparative statement of Buduchur Doinik Market. You have submitted for this also.
No,
What is this? This subsequently.
in 58, your lordship, I think it is,
What is this annexure C?
is the.
Comparative statement of Budusar Doinik Hat, my lord.
This is the next one,
Yes, this is in respect of the second NIT.
or where you did not participate.
No.
So there are 4 persons who have been found, but
Yes, my lord.
Buduchur 4 persons. Good.
Yes. Oh, that is
How much you quote?
56.
You have, your lordship, 22 lakhs,
Huh?
22 lakhs, 14,889 rupees. 60 page.
So they gave it to some Saraswati Namadas,
More equity repeated.
22 lakhs, 14,890.
889.60, 60 page.
Yours is? Or then there must be a lottery. How do you take care of? You are for whom? Mr. Rusi? Saraswati Namadas.
Your Lordship, appearing for respondent number 5. Your Lordship,
You are appearing for whom?
respondent number 5.
Who
And
is
the
it?
bidder in the subsequent NIT, Lordship.
Saraswati Namadas.
Pradeep Kumar Namodas,
Huh?
Pradip Kumar Navodas is the petitioner.
petitioner.
And which Saraswati Namadas?
Perhaps
Correct.
he is appearing, yes.
Yeah, I am appearing from Saraswati Namadas. Your Lordship, if you also permit me, I will take only 2 minutes. Your Lordship. For the very essence of litigation is to, there should be a wide.
So your bid was not open, financial bid was not open.
Financial bid was not open. But the technical bid.
So how do
was-
you say that you are the highest bidder?
Because I have put it my bid, Your Lordship. I'm saying
Ah.
that in technical bid, Your
Yeah,
Lordship.
they
the
have got good money.
person submitted bids and out of these two, only the bid of the petitioner was found valid. Now the question is that, Your Lordship, whether for non-submission of these two documents, they can, my tender application, they can create it as not,
You should have submitted.
whereas these two documents are not at all the required document, Your Lordship.
Bakijai? Did you submit the Bakijai certificate?
But Bakizai certificate.
Did you submit the
that
clearance?
document
No,
was
did you no,
submitted-
Mr. Khan, you tell me one thing. Did you submit the tax clearance certificate from Gwalpara Jila Parishad?
Lordship, see the comparative statement. Your
I'm not
Lordship.
done that. No, whatever name, they may make it a rose, maybe make it a hibiscus or whatever may be. I'm asking you. No, Mr. Khan, kindly directly to your point. Did you submit a certificate from the tax clearance from the
Zilapuri.
Gwalpara Jila? Did you submit?
Yes, that is written in here, Your Lordship.
Where?
Tax clearance certificate submitted as per
Tax
page
clearance
56.
certificate, ZPC, AP, GP, all. Yes.
Oh,
In
okay,
comparative
it has been
statement.
done. Now, what is this Bakijai document?
Regarding, he said,
Huh? Mister?
My lord, there are two cases, so that is why.
I'm only into his case first.
Yes, Pradeep Kumar Namodas. In this case, my lord, the comparative statement is saying that Bakija is not submitted, but I have not yet found where it is required in the tender.
No, Bakijai is not required.
I have not found yet, my lord. Whether it's there or not, I have not found.
But you have to put it in your tender.
Maybe, my lord. My lord,
You do one thing. Open the tender. The financial, have a look at it. How much did you quote?
my lord already opened.
22
If
lakh
one-
14,000,
Huh?
22 lakh 14,800.
1,4.
Yes,
And they quoted 18,000.
they have,
22 lakhs, 14,890.
That is their quote.
only sit-
The
40
private
days.
respondent, my lord.
No, what is your
Three-
quote?
My code is, Your Lordship, 22 lakh 14,889.60 page.
Here it's 90.
And they paid only 40 paise more.
That is not the question. You didn't know then, huh? You
Yes.
quoted this. What is this 40 paisa? Where do you get this 40 paisa business?
Because I have mentioned the figure, Your Lordship, what they have given and what the petitioner.
So show me. There seems to be no good reason.
My lord, Lordship may fix the matter tomorrow, my lord. Eh, I'll go through all the records, my lord, if there is or not, my lord.
Chalo, tomorrow.
Yeah, your lordship.
Wait. Mr. Dotto,
My lord.
Learned Council wants to say something.
Yes.
Kindly give him the
Yes, yes, yes,
podium.
sure, my lord.
Your lordship. And the answer, so I seek your lordship. Pardon
Tell
your
me,
lordship. I am having a
wait,
vocal cord
Mr. Council, tell me.
Yes.
Which is the clause in the NIT which says that there is a requirement of Bakizai notice and.
I am not on that. Absolutely not on that, your lordship. What your lordship, why retender, your lordship, the very essence of floating NIT is wide participation, so that should be a fair and competitive bidding, your lordship. Now, as per their own statement, para 7, kindly see your lordship, para 7, page 8, why retender? Para 7. May I read, your lordship?
Yes.
Yes, para 7, that the petitioner back to state, that the petitioner has submitted his tender application enclosing all necessary documents requirement as provided in the NIT data so and so to get a settlement of Buduchor daily market for so and so year. The tender application was opened on the scheduled date and time in presence of the tenderer or their representative. The tender application of the petitioner was found valid in respect of Buduchor daily market in first place as per condition number 7, the NIT. Although there are another tender application submitted for settlement, but it was found invalid. So there is only one responsive bid, your lordship. Only one responsive bid, that's why it has been retendered. Now, I have gone through the Panchayat Act and rules, there is no provisions, but as per the NIT, second part, clause 1, your lordship. May I
No,
take your-
no, tell me one thing, is the tender only for scheduled caste?
Yes,
You sure?
yes, I think. Scheduled caste participant, no? Scheduled caste certificate is the condition required in the.
It's a required,
terms
no,
of-
is it only for scheduled caste?
Huh?
No,
No, no.
he may be a bidder from scheduled caste tribe. It is not.
Perhaps it is not.
All
No,
compatible.
what I am, your lordship. So there
Okay,
was,
no, I got your point. Mr. Khan, I think we need not disturbing further. You see, one bidder is there. Then obviously they can go for, because in fact, if you see the comparative statement,
lack of competition.
the second bidder, he did not submit the financial, whether financial submitted separate envelope? No. Enter antecedent certificate? No. Antecedent is a must.
Lordship kindly see that rule 20, your lordship, lack of competition, my friend is referring in here.
Huh?
Lack of competition, yes.
No, I'm not on that.
Yes. but
Kindly
in
come
case
to
of one single.
So there
bidder-
is only one. There was only one valid bidder.
Yes.
In case of one valid bidder also, settlement can be made.
No,
No,
Settlement-
no, no.
Because
our-
in rules.
only on,
No.
Rule two,
we need not go further.
rule.
One valid bidder, they therefore want to go. Isn't that one of the stipulation in the procurement policy?
your lordship, yes.
What is that? You
Sub
tell me,
rule-
tell me the clause.
Sub rule 20 of rule 23 of the Assam
Eh,
Public
23,
Procurement Rules
20.
2020. It is very clear.
I'm.
Like what it is.
I just want to read out the,
Mr. Khan, I'm just estimating, can I finish off the matter at 4:20? When the judgment done and dusted,
Sorry, simple.
Lordship,
matter.
I-
how much time? That is the only estimation I'm doing, no more hearing.
Yes, no more hearing is, you get, in fact, the law is very clear.
no, from the. book
Sub rule
itself,
20.
Lordship, I am
No,
showing.
no, you see, there were only two bidders.
Yes.
The second bidder was absolutely courageous.
Yeah.
Chalo. I think that is, no, Mr. Khan, Mr. Khan remaining is for the division bench. That very merciful, good judges out there, they will consider your case. I cannot further. I need to dismiss it right away. Heard Mr. A.M. Khan, the learned counsel.
Kindly.
No, no.
If you
Heard
want
Mr. M.
to-
Khan, the learned counsel appearing on behalf of the petitioner, Mr.
R. Majumdar for
The
respondent
S.
number five.
Gupta appears on behalf of
Respondent number five.
no, you don't appear for respondent, appears on behalf of the 1 to 4.
Subsequently added respondent
You appear for 1 to 4.
Yes.
And Mr. So-and-so appears for a respondent number 5.
five.
The petitioner herein has approached this court being
Before starting, your lordship, I just want to point out
aggrieved by the action on the part of the Chief Executive Officer Gwalpara Jilla Parishad in issuance of a re-NIT dated 25/7/2025 to the extent of the Buduchur daily market and further seeking a direction that the respondent number 3 and 4 should settle the Buduchur daily market for the period 2025-26 in favor of the petitioner against his tender application submitted in terms with the NIT dated 5/6/2025 for the period 2025-26. Also, it is relevant to take note of. Now, the material facts which arise in the present proceedings is that a notice inviting tender was issued by the Chief Executive Officer, Gwalpara Jilla Parishad, dated 5/6/2025 for settlement of various huts, including the Buduchur daily hut. It is seen that in pursuance to the said notice inviting tender, 2 bidders, including the petitioner, participated in the tender process for the settlement of the Buduchur daily hut. The petitioner categorically stated in paragraph number 7 of the petition that the petitioner was the sole eligible bidder. And as such, the petitioner ought to have been granted the bid, ought to have settled the hut in question. Rather, the respondent authorities have initiated the re-tender notice dated 25/7/2025 for settlement of various huts, including the Buduchur daily hut, and it is under such circumstances the present petition has been filed. This court, by an order dated 4/8/2025, issued notice and further passed an interim direction that the respondent authority shall proceed with the NIT dated 25/7/2025, but however, shall not finalize the decision till the next date. This court further permitted the petitioner to participate in the fresh NIT process initiated by the re-NIT dated 25/7/2025, and the participation of the petitioner in the said NIT tender process dated 25/7/2025 shall not cause any, and it was also observed that the participation of the petitioner in the said re-NIT dated 25/7/2025 shall not cause any prejudice to the petitioner in the present proceedings. It is an admitted fact, as submitted by Mr. A.M. Khan, the learned counsel appearing on behalf of the petitioner, that the petitioner, however, did not participate in the said re-NIT proceedings. Be that as it may, the records further reveal that the re-NIT proceedings was processed, re-NIT proceedings initiated by the notice dated 25/7/2025 was processed, and one Saraswati Nomo Das was found to be the successful bidder as the said Saraswati Nomo Das was selected, having quoted, was selected in the said tender process. Post- The said Saraswati Nomadas thereupon filed application before this court seeking impleadment, and this court duly permitted and arrayed the said Saraswati Nomadas as the respondent number 5 to the instant proceedings. In the backdrop of the above, the question therefore arises in the instant proceedings as to whether this court should interfere with the cancellation of the tender process insofar as the Buduchur daily market, wherein the petitioner had submitted the bid and was found to be the sole bidder who was technically competent, and thereby interfere with the re-NIT proceedings that initiated by the NIT dated 25/7/2025. It is relevant, this court have duly taken note of the affidavit filed by the respondent number 4, wherein the respondent number 4 had categorically stated that in pursuance to the notice inviting tender dated 25/6/2025, in respect to the Buduchur daily market, the respondent number, there were only 2 bidders, of which one of the bidders were not technically competent. And as such, for greater, more competition, more participation, and it was decided that there should be a fresh notice inviting tender in respect to the new bidder, in respect to the Buduchur daily market. And pursuant thereto, the notice inviting tender was issued. Read NIT date 25/7/2025 has been issued for not only the petitioner, not only the Buduchur daily market, but also various other markets. The decision, so it is relevant to take note of that this court, while exercising the powers under Article 2 to 6 of the Constitution, is not to decide whether the decision is right or wrong of the respondent authorities. What is to be decided is as to whether the decision is fair the decision-making process is fair and transparent. For materials on record, and more particularly the affidavit filed by the respondent number 4, it is the opinion of this court that the decision for going for the retender does not smack of any arbitrariness or any illegality or unreasonableness. For this court to exercise the powers under Article 2 to 6 of the Constitution. Consequently, this court does not find any merit in the instant writ petition. Accordingly, the writ petition stands dismissed. Interim order passed earlier stands vacated. The respondents would be at liberty to finalize the tender in respect to the Buduchur market, daily market, in terms,
Sub-rule 23.
market. Yes, ma'am.
Your Lordship, in this next case also same, only 2 participants.
What?
In next 20, item 20.
Who is the petitioner here?
Here in the petitioner is Mukut Medhi. I am respondent number 5.
And who is he?
He is in 22.
Whether he participated in the second retender, whether
Ah,
and quoted 27,67,962. But one another, my lord, Abdul Motinur Rahman, he offered 29,27,652.
Same reason for retender, same reason, only 1 valid participant.
But herein, your lordship, 3%, in respect of the past NIT, 3% participated. And only the bid of the present petitioner was found responsive.
Yes, same
So
reason.
my case is that the one responsive bid, it doesn't mean that settlement cannot be offered.
No, no.
But in
Rule is saying so.
Saying in para 7, they have stated only 1 tender found valid, others invalid.
Rule 23, Rule 23, sub rule 20,
Yes.
2, your lordship kindly see, in respect of one responsive bid, the settlement can be made.
Where a situation arises where after evaluation of the user ends up only with one responsive, where the committee shall check as to whether while floating so and so, right. If not, the committee shall recommend cancellation and issue a fresh penalty after strict adherence to all the iman and so and so.
And regarding the lack of competition, your lordship, rule 20, your lordship says, provide certain condition, your lordship. That if that condition satisfied, then only they can. The
What?
But the problem.
Meets all necessary requirements to encourage competition, so and so. Now, when ends up with only one responsive bid only. In the earlier case, only one responsive bid.
One responsive bid, your lordship.
In the earlier case.
Earlier case.
Yes.
2% participated, and out of these two, that in my tender, it was also, they have held that it was non-responsive.
But I
But
think
not
it is
submission of
responsive.
That to document.
Yes. No, that is wrong, but then also there is only by other, you cannot. He did not submit anything.
The ground for which, your lordship, they have taken decision, your lordship, the tender evaluation committee, for what reason they have issued re-NIT, your lordship. Can you see the, I'm just reading the 20, your lordship.
Where?
What are the conditions given in here?
Page? Page? No, that I have seen it. Page? What you are going for this time?
Lordship, page 82, your lordship, kindly see that.
No, the last time some reason was given, na? Of the evaluation code dated 24/7, dated, page the 24/7? Evaluation committee?
Is that
Huh?
in here, page 56, your lordship, kindly see.
I passed an order, na?
In that case, your lordship, that.
No, here also 13/8/2025, I passed a stay order.
Yes, stay is there, your lordship.
Mr. Khan, forget about that. It has gone for in oblivion. We are not on that. We are here.
Yes.
Now here, I passed also a stay order,
Yes.
taking into account that, kindly see paragraph number 9 of the year. This court have duly perused so and so, and it is seen that only when the evaluation upon finding there is only a single bidder and there are no proper notice being issued, such exercise can be carried out. However, a perusal of the minutes of the year which is kept on record and marked with the letter X here. Meeting was convened to evaluate the technical bid for the 10 numbers of huts so and so. On scrutiny, it is found that out of the 10 numbers of huts received only for 7, tender of Sunu Prasad withdrawn as injunction issued by so and so in respect to so and so. The committee rejected 18 numbers of tender papers due to non-submission of them with the other relevant document. After scrutiny, it is found that there are only one responsive bid submitted against each of the 3 markets, namely, what is this market?
Cattle market.
Pushuhat.
Huh?
Shutarpara Pushuhat.
What?
Shutarpara Pushuhat. Cattle market.
What is the name? Sutarpar.
Yes.
Sutarpar Pasuhat. That one responsive bid submitted against each of the 3 markets, so and so, so and so.
The first one is the Shutarpara.
Okay.
One responsibility. So they won't state.
So here the same principle is
Same,
followed.
they have also stated in para 7 here. Only one responsive bid.
He participated in the re-tender and he failed.
No, but he was permitted to participate without prejudice, I suppose.
Yes. Principle will follow. Cover this case also. Only one responsive bids.
Wait, Mr. Khan,
Yes.
where did you take that leave from this court to participate?
My petition, your lordship, I have.
No, 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 no. Here in order, like in the earlier case, I gave you an order, na, specifically.
Yeah.
That you may participate without prejudice.
No, no,
Where is he here in this order, in this case?
that order is, no, no, before filing this writ petition.
You
your lordship-
participated.
Yes, yes.
Then how can you
And-
challenge the NIT?
No, in my writ petition also, I have mentioned your.
Mentioning is different. You see, there is a difference out there, na? Estoppel comes into the being. In that case, therefore, I gave you the specifically.
Situation was like that, your lordship, initially they, assurance was there, your lordship, but at the end, they have failed, your lordship, and at the end, your lordship, the petitioner submitted. Initially, the assurance was given to the petitioner that we will give settlement to you. I have made a statement in my writ petition, your lordship.
You also know, Mr. Khan, I also know, they also know. These verbal assurances, they don't. It has to be in black and white.
In here, your lordship, I just want to point out one thing, your lordship. In case of one responsive bid, your lordship, if the evaluation committee finds it, the condition what you were mentioned in June 20,
3.
yes, one, your lordship,
Mm.
that in what circumstances they can issue retender, your lordship. When a situation arises where, after evaluation of the bid evaluation committee ends up with one responsive bid only, the committee shall check as to whether while floating the notice inviting bids, all necessary requirements to encourage competition like standard bidding, so, wide publicity, sufficient time for formation of bid, etc. are fulfilled. Whether these are the conditions fulfilled or not, but I have not found anything, your lordship, in that impugned minute, your lordship. That these are the conditions were not fulfilled, and accordingly we held it that we need to go for fresh NIT. And the second, your lordship, in 2, it provides that in case of one single bid also, one responsive bid also, they can proceed settlement, your lordship. 2.
What? Subject to the provisions of near in the finance department by prescribe further steps or measures to be adopted in the process of invitation of the state superintendent may recommend in the state government benchmark.
Exactly, your lordship, this point, your lordship, I wanted to make in earlier case. The minute, your lordship, nowhere says about that these are the conditions were not fulfilled, and accordingly we have taken decision to issue re-NIT. Only merely they have stated in the minute that one responsive bid, so we held it to issue re-NIT.
So 23, 22.
22,
So these are to be looked into.
yes.
Without looking into, they cannot certify. What do you say? I'm not signed the earlier order. May change.
My lord, in all the cases, my lord, Bahats, my lord, retender was issued to attract more bidders, my lord. And in the earlier case, lordship has seen, my lord, the 7 bidders, my lord, they participated.
Maybe, but you didn't get more than that.
Wide publication was there.
The difference is only 40 paisa.
My lord, bid was not open, my lord.
May not be.
Malafide is not there, that was the answer.
No, Malafide is not there, but the fact remains out here that if you apply some public procurement rules, you have to abide by this.
My lord, after the first bid, my lord, my lord observed that the maybe the wide publicity was not there. That is why they have retendered, my lord, giving the reason and widely published, my lord.
Where is that observation?
My lord,
There was no white published.
my lord, as the only single responsive bid was there, that is the sole reason is also there, my lord. Because only single responsive bid was there.
No, did you look into the other aspects?
My lord,
The bid is technically qualified. Price quoted by the bidder is accessible to be reasonable.
this
The
financial
is
bid was not open.
unconditional, complete in all
Financial bid was not open at that time, my lord, before retendering. After the second retender only, my lord, the financial bid was open. And moreover, my lord, he participated in the retender, my lord. He failed,
Not in the earlier one.
my lord,
It
there
is
is
still, it is not signed, nothing happens.
in the earlier on, my lord, lordship has, the honorable court has given liberty to participate in, my lord, but he didn't participate.
No, he didn't participate, that is one thing. But the fact remains that you can't rely on public procurement.
My lord, in the tender, it is clause is there, my lord.
So if it is there, then you have to comply with this. How do you take care of
My
this?
lord, in the earlier case, my submission will be, my lord, as it was widely published, that is why 7 participant was there, my lord. Before that, only 2 bidders were there. After retender, 7 has participated.
How does
Seven.
it matter?
My lord,
7 or 100 participate, but unless you want to follow the public procurement rules,
my lord.
you have to follow as it is. So you see, there has to be a recommendation subject to these. Don't you think so?
Lord, that is there, that 100% that has not been, may not be followed. But the spirit, my lord, spirit of the rule, my lord, is there, my lord.
No, that means if you have only one bidder, every time one bidder, so then you will keep on cancelling.
Then 1055 will come. 1055. If not adequate bid, my lord, value, then we can directly handle. Section 1055 of Panchayat Act, my lord, is saying if no adequate value, then we can directly handle also, my lord.
You can directly handle, very well you handle it.
Yes,
I'm
yes.
not on that.
My
But
lord,
the fact that if you want to apply 23.3, Rule
My lord.
23.20,
yes.
apply. But you have to apply as per how it is. You cannot just go by on the first point.
My lord, my submission would be that spirit of that rule, my lord, they have adopted, my lord,
You
and
say that the spirit of the rule. Because you see, to hold him technically not responsible was wrong.
maybe, yes.
So he was technically responsive. Because you have held him to be technically non-responsive for what reason you have
Bakizai,
not
Pen
mentioned.
Garden, yes.
Except for Bakizai as well as Dia, which were not the requirement as per the tender condition. So under such circumstances, here is a case that how could you apply 23.10.20? Unless there is an observation to that effect that these are the things which has happened. Did you check as to whether while floating the notice all necessary requirements to encourage competition were there or not? Is there a single sentence in paragraph of the respondent number 4 in that regard?
No.
Then how do I help you?
My lord, in the earlier case, my lord, more affidavit contains. Lordship is taking earlier case or
Earlier case.
earlier case, yes. Our statement is that, my lord. May I read, my lord, page 51, my lord, I'm reading. It may be mentioned that the 2 bids were received in respect of settlement of Buduchar Daily Bazaar, and petitioner was one of the 2 bidders. However, both the bidders were found technically non-responsive. As such, tender committee was left without no other option but to invite retender. Therefore, as the
reason is wrong. The reason is not 23.10.
my lord,
Unless you come up with that feeling,
my lord,
because unless this court needs to look into that aspect.
my lord, perhaps, my lord, as the my lord authority.
Unless you show that the Bakizai notice has, you see, the petitioner did not submit only 2 documents. Bakizai notice as well as the
Bakizai clearance certificate and PAN card along with
PAN card.
yes.
So both are not required. But I saw one thing, that in respect to the second portion also, you asked for the same and rejected few on the basis of the PAN card and Bakija.
Yes, we have in fact given notices to submit, my lord. Given notices also to submit that, my lord, in the second case.
But
You have given notice
Yes,
no,
for submission?
for submission of those documents, we have annexed it, my lord.
but there is a provision, your lordship. for
Page
issuing notice
59.
In case.
Page
59 to the petitioner, my lord.
of the earlier case?
No.
The
second-
later case, my lord.
The first case, no notice has been given.
My lord may be given, my lord,
Where?
4586, my lord.
Page,
WPC.
page?
Page 59.
I can see.
His signature is there at page 60.
Huh?
Page 60, my lord, annexure D1.
Which, who has filed that affidavit?
Respondent number 4, my lord, in the WBC 4586 of 25.
You people have, don't see, you are in the minor exit. Members present. PA. Where?
Page 60 is the vernacular, my lord.
Page?
Page 60.
Mukut Medi, below mentioned documents were not found with your tender submitted by you regarding the notice for Sotapura. Therefore, in terms with rules of Iman, you are
And-
requested to submit the documents as the office has been sworn. Bakizai papers, police report, PAN card. But 2315 could not have been applied here for police report. You see, 2315 is only for historical documents.
My lord.
Bakizai papers cannot be historical. Police report cannot be historical. PAN card can be,
Yes, yes.
isn't it?
My lord, actually, this was annexed because petitioner alleged that we have not given notices to other. Page 62 and 64, these are for other also, my lord. Same notice, my lord.
Now here, how many bidders you found?
My lord. For Sutarpara Posuhat, my lord.
So if here you have given, wait, mister,
My lord.
if in this case you have given this, why haven't you given that into him
My lord,
in that one?
because my submission is that, my lord, the earlier, in the first tender, my lord, it was cancelled only because, my lord, because of the single responsive bidder.
No. No. Because no responsive bidder.
My lord, in the second case, there are two cases, my lord.
No. The second I have seen it, Mukut Meti.
Yes.
Don't worry. But the first one,
Ah.
it was done on the basis of only, there were no responsive bidder.
Because, my lord,
In a wrong
for the
understanding
authority,
of PAN card and Bakijai.
because the authority, my lord, he, at that time, my lord, the normal, regular president was not there, the committee was not there, the district commissioner was headed as the chairman, my lord. He decided, my lord, as, he found, my lord, in the, lordship may kindly see the page 56 of Pradeep Kumar Namodas, the earlier case. This is the comparative statement, wherein the format itself is, it's written as Bakizai document, land documents and PAN card and everything, my lord. I don't know why these are written here, my lord. That is why
Otherwise,
I've at that time,
if you remove the Bakijai here,
yes.
he is responsive.
Yes, but only single responsive,
But that is not the reason.
because, my lord, at that time, my lord, the committee
So
hold, my lord.
therefore, your very decision is wrong.
But if we, at this stage, my lord, if we, my lord, that was wrong, my lord. But otherwise also, my lord, in a single bid only, my lord. If lordship will assume that his bid was correct, then also only single bid, my lord. Maybe that reason was not put at that time.
Then single bid, how can you operate single bid without that aspect,
Yes,
the satisfaction?
my lord, I'm also fairly submitting
I'm also
If-
fairly
if this-
submitting,
if-
I'm also
if-
appreciating you fairly.
My lord, if this will go also, my lord, then also single responsive, my lord, like the next case, my lord.
Then why didn't you make a submission that even if it is wrong,
My lord,
what
because
it would have resulted in what? This court can't grant him. It would have gone for the decision, it will go for a fresh tender.
my lord, that is why, my lord, I am 100% not sure whether these are mandatory or not. Because I have not found, maybe some circular or I don't know how it
Yes,
is
yes.
written, my lord.
Ask him, ask the other person, he's on paragraph 7.
পুলিশ স্টেশন এইটো বেলেগ বস্তু বাকী জাগিৰ কথাটো ক'ত আছে So, my lord, being the authority, I have not supporting the petitioner and respondent, my lord. It's up to lordship, but we should not, my lord, my concern is revenue, my lord. We are not with petitioner or respondent, anyone, my lord. Especially being the standing council of Panchayat, my lord. The department is not with the petitioner,
Now you do one thing. You have the financial bid of the earlier period, na?
my lord.
You think about another submission which you can make. That in the circumstance, this court holds it. This court can't issue a mandamus to give it to him.
My lord,
I may hold that the issuance of the NIT is wrong.
my lord, second one, retender.
That is the only thing I can do.
Yes, yes,
I can't direct you to give it.
my lord,
You may still have a decision.
my lord.
They're taking into account that, so they want to go ahead. Then it will result in the same thing. But only thing is that then the petitioner gets a chance of participation. Khan, in this case, you do bad case. Mukut Mehti is a bad case. The other one, you may have a case in that. That is the only way. Because you see, I can't direct.
My
It
lord,
can be given
may I
to, I
suggest
may
one thing?
set aside the NIT. If I set aside the NIT, the only thing is that you get a chance of participation. Nothing more than that.
My lord, may I submit one thing? In
Yes.
the earlier case, there are 3 responsive bidders which bids are same.
Two.
Two, my lord, yes.
Of which one is absolutely non-responsive and the petitioner was responsive.
After the retender, my lord, I'm submitting. 3.
Understood, but the petitioner did not participate.
If lordship allows him the same rate, because it is not finalized yet, only financial bid was open. There are 3
No,
highest
it has
bidders.
for a fresh tender.
We will add, my lord, after fresh tender, maybe some more revenue will come. That is a different thing, my lord.
No, it may only go for a fresh tender, nothing more than that. Thereby, he can also participate. He has not participated there. In this case, if that is the reason he has participated for which I can dismiss this petition.
Yes,
He cannot raise that issue here.
yes, yes,
Because he has anyways participated without taking the leave.
yes,
Their leave was granted, he did not participate
yes,
in the second leave.
my lord.
So therefore, the question which this court can pass an order is only to that extent, that to go for a fresh bid. Now, if you go for a fresh bid, because you can't open, once you have already cancelled him, the earlier one, holding him to be non-responsive, that was wrong.
Yes,
So you were responsive. But the question is, the decision is not wrong. I cannot direct you. So the only option is you can very well consider to give it, open his bid and proceed, or you may take a decision that this is too less and follow 2310, 20 and go for a fresh bid.
my lord,
I think that appears to be good.
my lord.
Anyways, think about it. We'll have it on Friday,
Friday.
It is in respect of first case.
first one.
Yes.
It is not finalized. I may dictate many things,
Yes, yes, participate.
but this is the issue. But this case,
In the meantime, my lord, PAN card and Bakizai thing, I will
you
confirm. my
just-
lord.
I'm giving you that.
Yes,
The reason why I'm not finishing is that if he is technically non-responsive,
yes,
check out the area, then obviously, because I fail to understand. Every time you have issued a notice to get him these documents, meaning thereby, there must be somewhere It may, you are only looking, maybe looking into the English version. Hey, well, look at the year or ask your people why they are insisting on the Bakizai. Because in this case also, notice was issued for him to produce the Bakizai and the PAN card. And he has produced it, I suppose. So therefore, the question is there must be somewhere something.
Something, yes.
Otherwise, why can he, you can issue a notice?
Maybe, my lord, this was, the model NIT was recently published, my lord, by the government. Lordship has held with that earlier judgment, my lord, past time judgment, my lord, where earlier clause 10 was cancelled. Then a new model was introduced by the government, my lord, introducing that 10% thing, my lord. My lord, maybe before that, the earlier model, it was there, my lord, maybe. The Bakizai
But
thing.
why will they make a mistake in the subsequent?
The, yes, my lord, because these are formats, my lord, my lord,
Have a
yes.
look at it. You have a look at it.
Yeah, I'll look at it.
So then in his case, the first case,
Yes,
he only gets an opportunity to participate.
participate,
That was against a new fresh thing.
my lord.
He doesn't get anything.
my lord.
But in the second one, it's a case for dismissal. He has already participated out there without taking the leave.
Yes.
So now he cannot question this.
But that order, my lord, lordship is passing,
Something together on that day.
my lord.
You let him have the happiness of one of name. Stay
My lord,
with
lordship has
another,
already
the
dictated
sadness.
one, maybe, my lord,
Taking-
bifurcating the
It is
written
because,
numbers.
but Mr. Khan, it is because of my order of 13.8, you are getting this benefit. Because in my order, because normally I don't grant a stay normally. And if you get a stay, I give due reasons. So paragraph 9 of my order makes it very sense that you have to have some reasons. And this court looked into Annexure X you produced that day. You appeared, no?
Yes,
You
yes.
appeared, Mr. Doctor.
I
Yes.
yes.
So that is why, that what are the reasons? So here they are, because your reason is wrong there. So anyways, we'll have it on Thursday. Thursday is not too many matters. Friday,
Friday, well,
2 p.m.
2 p.m.
A to B today,
Obliged.
2 p.m.
In respect of item
I'll
19.
oblige.
Yes, both 2 p.m.
Both.
Both.
Italo both,
Both.
yeah, hidden order pass kori.
No disposal. Don't worry. The matter doesn't get disposed like.
I'll oblige, my lord.
Yes, Mr. Das, every time you have a problem, what is your,
Item number 7 may be fixed by the next week.
okay, give a date.
7th.